All right. Here the Court of Appeals of the State of Michigan is now in session. The Honorable Stephen. The Honorable the Bill Cox, presiding, the Honorable Adrian and Young, Albert. So I'm here for detention and they shall be heard. I'll say the United States, the State of Michigan, and the Honorable.
Hi, everyone. Good morning and welcome to the second panel of the June 2026 case call. As you heard, I'm the presiding judge. My name is Adrian Young. I'm joined today by two very shy people, so I'll take the liberty of introducing them. And to my right is Judge Stephen Borello, and to my left is Judge Chris Trebilcock. And all jokes aside, they're both integral parts to my ability to function successfully at this court. And I feel really grateful to appear with both of them today. And I'm sure you'll feel the same after oral argument. So with that, all of you, I think, have practiced in here before, but it's worth reminding you that there are some cases involving criminal sexual conduct. There are some cases involving child victims, termination of parental rights. Please think before saying someone's name and realize that this is all streamed onto YouTube. So just be considerate of that. And then also, you all know that we've worked really hard to prepare for this case call today. At the same time, we are interested in hearing from you about the critical issues that may not have been completely spelled out in the brief, especially if in the time from your filing to now, there's been any intervening case law. That's incredibly helpful for us to hear. And so with that, I will call I'll call the first case. And let me just say this before I do. If I mispronounce either your name or your client's name at any point, please don't hesitate to correct me. I do want to get that right, both for the sake of the record, but also out of respect for the parties and you, the practitioners here today. So with that, we'll go ahead and call the first case. Mr. Simon, I see you up there already. It's case number 1, docket number 371443. People versus Brandon Michael McKean.
Good morning, and may it please the court. Jonathan Simon on behalf of Mr. McKean. Your honors, I believe that my brief sets forth 3 reasons for a new trial. People have not responded, and so I'm assuming that they agree.
So I was kind of surprised at the oh my God, I need a lawyer, but then after reading the record, it felt like the police actually handled that correctly, but that wasn't really reflected in your brief.
We don't really know that because the tape was garbled. There was no accurate recording. All we have is the detective's recitation that, yes, he wanted to continue. So I re-Mirandized him and we continued and he made a statement. We don't have any verification of that claim.
But that's not uncommon. I mean, it's not ideal. Don't get me wrong. I think that there should be clear recordings and that's the best evidence. But the record reflects that your client said, oh my God, I need a lawyer. The police stopped immediately. And then he said, actually, never mind, let's keep going. And then they re-Mirandized him.
According to the officer, yes. But I think that the fact that he asserted his right to counsel should have concluded right then and there. And I don't know that the re-Mirandize is cured.
It stopped.
Yes, but then it resumed.
But doesn't our law allow a defendant to reinitiate?
Well, I think the law also requires that
So that's a
the
yes.
statement be video recorded.
That's a yes to my question.
Yes.
Okay.
Reviewing my brief, I do note that apparently there was no record of the closing arguments and the verdict. This was a bench trial, but perhaps maybe to complete the circle, we maybe should have the judge make some findings of fact and conclusions of law.
Mr. Simon, I do have one question. I saw in your argument about some of his ability to waive about there was no inquiry into his educational level in your brief, but I didn't see any case law saying that a court has a duty to inquire as to the defendant's educational level or any diminished capacity or anything like that.
No, but there is, I think, a general requirement that it be a knowing and understanding and voluntary waiver. And I think that education is a crucial element in terms of whether or not Mr. McKean knew and understood his right to a jury trial and what it means to tender a waiver.
Okay, but there, answer for me two questions. One is, are you aware of any case law that whether it's in Michigan or at the federal level that requires an inquiry into a defendant's educational level?
No.
Okay. And then the second question, was there any evidence or I didn't see anything in the record referencing or establishing what defendant's educational level was in this case?
That was also not part of the record. I think it is included in the pre-sentence report, but since I didn't raise a sentencing issue, the court does not have that report.
Okay.
In all candor, I did have a recent published opinion. I can't recall the name of my client, but it was only a few months ago regarding waiver of trial by jury. And I think that was it? Maybe it was, no, I apologize. I think it was actually waiver of right to counsel. Never mind.
Okay.
All right.
Any other questions? Thank you. This case will be submitted. The next cases I'm going to call are consolidated. So I'll call them and then we'll talk about oral argument, what's happening, who's doing what. So cases number 3 and 4. First is docket number 366-830, People versus Terrell Deontay Shaney.
I don't think they were consolidated. I think they're separate.
Oh, they're not consolidated?
I don't think so.
Are they consolidated? No, they're not consolidated. Delete everything I just said. Edit it out of the YouTube video.
I like that she asked the attorneys after I said, I don't think they're, well, what do you know?
Yeah.
I'll ask the lawyers.
Delete all of this from the YouTube. Okay.
Yeah, exactly.
All right. All right. Let's try this again. Calling case number 3, which is completely by itself. 366-830, People of Michigan versus Terrell Deontay Shaney.
Good morning. May it please the court. Ian Kerpon, we have Mr. Cheney. Let's get right to it. First issue is ineffectiveness as a counsel. I raised several issues under issue number 1. The first one, failure to call an alibi witness. I realize it's his mom. And I know there may be some, are we really going to believe someone's mom? But my counter is always, usually your alibi witnesses are going to be family and friends. Rarely is it going to be strangers. So I don't think it's unusual that Mr. Cheney would have been with his mom or around friends and family.
Was there evidence in the record that the mother was interviewed by counsel?
No, unfortunately, trial counsel passed away. So
I'm familiar with that. He was a classmate of mine in law school, but was there any record before he passed away that there was contact?
No, other than the affidavits that I submitted.
Was there any evidence that your client told him that he had an alibi defense that his mother would provide?
That's provided in the affidavit, yes. Was it part of the lower court record? No, it's part of the motion to remand that followed the court. I'm asking this court to remand back.
I know what you're asking.
Okay.
It just seems to me that, once somebody passes away, it's a lot easier to make claims than if they're there to rebut them. So that's why I ask if there's anything on the record, because, choosing who to call and who not to call are really, really strategy of counsel. I called a mother once who completely sank my client's case as an alibi witness, and I saw it happen more than once. So I'm not sure that this wasn't, good old strategy.
And yeah, and I've called alibi witnesses before too, and the thing I always explain to the jury is, who are you with last night? Jurors, family and friends. I mean, it's just, doesn't mean that
Well,
they're any less,
I don't care
doesn't
that
mean
it
they're
was
any
a-
less credible.
No, let me finish. I don't
Okay.
care that it was his mother. What I'm saying is that it was a strategy decision. It doesn't matter what the connection is, but that was a strategy decision, and that we don't, look, your client, in essence, your client doesn't get two shots at the apple. You don't get to go to trial, not call somebody and then say, hey, my lawyer should have called so-and-so. Oh, well, we'll give you another trial until your client gets it right. So
Well,
that's how I see this.
and there's cases out there it's ineffective to not call witnesses. I mean, I raise this issue a lot and certainly comes up a lot with not calling certain witnesses. And when
Let me ask you this, your client's affidavit says, hey, I told my attorney about this and then there was no follow-up.
The affidavit's the affidavit. Yeah. I
No,
don't
but I'm
know.
asking you what it says.
Oh, I'm sorry, Judge.
Yeah.
You know what? I'll be honest with you. I've not looked at the affidavit. I looked at it briefly yesterday.
Uh-huh.
So I can't, I'm sorry. I don't have it memorized with what it exactly says. My apologies.
Okay.
Counsel, I guess my question, setting aside the alibi witness, you raised issues with both the Facebook post and the text messages being admitted.
Yes.
Do you have to be successful on both those challenges to actually have it make a difference in the overturning and reversing?
Okay. So we got the
Or
text
vacating, I
messages,
should say.
and I think just the Facebook post by itself.
Yeah, either the Facebook post by itself and then the text message. Do you have to have us find error on both those issues in order to be successful?
No, I think either one of those issues is enough because both were outcome determinative in this case. I mean, the text messages themselves are,
But if they're both outcome determinative, don't you have to have both of them? Because if one stays, then wouldn't that mean the outcome would be the same?
yes, right. But I think my understanding from the question of the court was if we find do we have to find an error on both?
Correct.
Right. But I think you can find just an error on one or the other.
Okay.
Because I understand with the Facebook posting, there was jury instruction. This isn't substantive. This is only to show the witness, may have been scared. But of course, there was information within that Facebook post that implicates Mr. Cheney in the crime because it's the police report and their statements in there. And certainly the Facebook posts, you didn't have to admit it. You could have done it through impeachment. The text messages are incredibly more damaging here, and specifically the way that the prosecution got him in was through, at first, the December 2017 interview the police had with Mr. McCaskill about an alleged 2011 conversation with Mr. Cheney, which Mr. McCaskill denied even having at trial. And he denied even sending those text messages too. So I don't know how the text messages came in because we denied sending them. It's not a admission by party opponent, and it's not a present sense impression if you don't say I never sent those. So when we're looking at the 2017 and how they got it in through 803.5, certainly Mr. McCaskill denied even having a conversation back in 2011. In 2017, it wasn't fresh in his mind. So I don't know how they were able to get the 2017 conversation to bring the 2011 conversation into trial. I don't see how that was possible. I don't see why the court allowed that, considering in 2017 the conversation wasn't fresh, and Mr. McCaskill even denied it even happened later. And that's sort of how they bootstrapped getting the text messages in, because I don't know how else they would have got them in, because again, Mr. McCaskill denied even sending it.
So the procedural history, sorry, were you?
Nope, I'm good.
Okay. The procedural history of this case is, did you file a 7208 in the trial court? Is that what happened? A 7208 motion for a new trial?
Yes,
Okay. But there was no hearing,
there was a motion hearing, yes.
but no, but again, there wasn't
No.
granted. At the time of the hearing, you did not present the trial court with the affidavits you now present to us, correct?
That's correct. I did not.
Why?
I was in the process of trying to get it from his mom.
Uh-huh.
I was working on that. Mr. Cheney has been and was incarcerated in Upper Peninsula, Michigan. So working on getting that one in. It's not the fault of my client or Miss Cheney. It's on me. So. But and again, turning back sort of the IAC issue here, I do think it's ineffective for not asking for lesser included second-degree murder here. Your client's facing natural life. I understand Miller's now extended to 19 and 20-year-olds, but you can still do life, and certainly should be able to give the jury the option here to not convict him of something that involves natural life. Especially
How is that not a strategy decision? That's a very common strategy decision, right?
Right.
And then either all or nothing. It looks really bad when it doesn't work, but when it does work, you're a genius. But like everything else in a trial, you don't know till it's over. So why was counsel ineffective? Are you saying we should adopt a rule that in every first-degree murder case, counsel must ask for a lesser included?
And I'm not asking the court to do that. I think it's a case-by-case basis, and certainly in this case. And I remind the panel, and the prosecution argument in their brief was the evidence was overwhelming against Mr. Cheney. So I think in that regards, you have to ask for something like a
But your
lesser.
client also contended at trial he wasn't there.
Right.
Wouldn't that confuse the jury? To sit there and say, well, wait a second, if he wasn't there, why would we convict him of this? And it could turn out the other way too, could it not? That maybe they were going to acquit him. But they said, well, we'll compromise, we'll do murder too.
That's very possible too, Your Honor. I mean, juries can do.
Yeah, strange stuff and often do.
Right. And in this case, so like what the jury did, of course, they found Mr. Cheney not guilty of the firearm offenses, which I found to be pretty interesting. And everything shook out here in this case and what the jury may have been thinking. And that sort of gets to, sort of requesting, and I guess, Your Honor, you can argue my client's not there, but the jury can still be instructed on certain things and you can still maintain your defense. I mean, they see it, all the time.
Yep, you can, certainly.
It's self-defense, but you still want the manslaughter instruction. I've seen that before.
Yep, so have we.
Right. And certainly when you're looking at an innate abetting theory here, maybe we should ask for a mere presence instruction here. I understand as instructed, but the defense specifically says you can be present and know what's going to happen and still be found not guilty here. Of course, the jury was never given that. And given their verdict of he's not guilty of the felony firearm offenses, either as a principal or an abetter, certainly I think the argument can be made that the jury may have believed Mr. Cheney had no idea his co-defendant had a gun on him. It certainly helps with the felony murder issue and the armed robbery issue, maybe a little less so with the home invasion. You don't need a weapon for home invasion. But certainly I think a mere presence instruction there would have given the jury a little more to think about there. They're like, hey, he can be present, know what's going on, but still not be found liable as an aider and abetter.
Thank you.
Yes. I know I sort of jumped around. I just want to, the affidavits I submitted wasn't because I knew trial counsel passed away. It wasn't anything strategic on my point. I just want to make that clear to the panel, and nothing with my client was like, hey, let's raise this now because he's passed away. Then we kind of talked about issue 2. Issue 3, unanimous verdict here on the felony murder. They sort of said, well, it can either be the home invasion or the armed robbery, but there's no requirement that the jury had to be unanimous on which one the predicate felony was, either armed robbery or the home invasion. I know I cited to an unpublished case. There was some language in there like, obviously I know the one case was insufficient evidence that was part of the issue there, and that panel may have come out differently. But I still think here you need to have a unanimous verdict as to specific which predicate felony it was, specifically given that the jury found Mr. Cheney not guilty of the firearm offenses. Lack of sufficient evidence kind of piggybacks into what the jury verdict was here. Lack of malice on the felony murder issue here. We have a situation where, again, where the jury found him not guilty of the firearm offenses here. I understand if he's armed, we know he's armed, malice can be inferred here, but we don't have anything like that. And certainly Mr. Cheney should be held responsible for the unknown actions of his co-defendant here, especially given he didn't know if he was armed or what kind of weapon on him. So certainly that applies to the felony murder issue and the robbery issue. Facebook post we talked a little bit on. Miller hearing. I think me and the prosecution agreed you get some Miller hearing. I'm asking for a different judge on remand. At sentencing, the court basically said, you deserve life. That's what you should get. Called him a coward. Said he intimidated witnesses. They looked unconcerned. And certainly, I would think the trial judge has made his feelings very clear. Mr. Cheney deserves life. That's what he should get. And I don't think on resentencing, he's going to be able to get those thoughts out of his mind and replace them. This wasn't an issue of a legal error or a misunderstanding of the law. This wouldn't be duplicative or wasteful. Miller factors are something completely different than what the judge had to do at a trial. There'd be no waste or duplication here. And I think preserving the appearance of fairness and justice certainly outweigh any waste or duplication there. And
What specifically would you cite that the trial court said that is sort of different and unusual? Because, that's a pretty extraordinary step you're asking us to take to reassign. And, at first blush, those comments aren't terribly unusual that a lot of judges say when sentencing somebody who's been convicted by a jury.
But I think he's pretty clear. Life without parole is what you deserve. Pretty clear, called him a coward. Thought he intimidated witnesses. Sat there unconcerned. I think those are pretty strong statements that the judge personally. It's not like the judge said, well, the jury found you guilty of first-degree murder. I have to sentence you to life. If he had said that, I'm like, well, okay. But here, it's pretty specific. It deserved a life sentence. So I don't know how we go back in the Miller hearing and the judge is going to go, yeah, you know what? You're right. You don't deserve one. I don't know how the judge is going to be able to get that.
The prosecutor filed a request for LWAP for this individual.
Yes. Yeah. So there will be a Miller hearing or maybe not. I don't know. This panel could order a new trial, hopefully. So I have a need for a Miller hearing. And I know I filed some motions yesterday. I saw the order this morning. Any questions? I'm brief.
Okay.
Okay. Thank you.
Thank you.
Can I jump in and just ask you a question?
Yes, Your Honor.
Oh, yeah, put your name on the record.
Thank
Good
you.
stuff, yeah.
May it please the court, Katie Jory on behalf of the people.
So here's so the fact that trial counsel is deceased is kind of being used against both people, right? Like it's used against him because, he clarified it wasn't strategic, but it makes things hard. But we can't also say in every situation where a Ginther is request and the trial counsel dies, you can never have a Ginther again. So there's both sides of that coin is my point. And here I understand there's case law and just the reality that like family members as alibis, I think probably moms in particular, that's where I saw it the most in my practice, are called into question. But the difficulty I have is that the trial court didn't actually judge mom's credibility yet. So that can happen without trial counsel. And so why not remand for a Ginther hearing limited to the alibi issue?
Well, Your Honor, I completely take your point on that issue. Obviously, with a Ginther hearing in this case, there would be the circumstance where Attorney Heyman would not be able to get on the stand himself and testify to what he did or actually did not do in this case or his trial strategy. I would rely upon what Judge Varela was speaking to earlier, which is the fact that this trial strategy and specifically who is called as a witness is very much left to the defense counsel. And as mentioned before, yes, a mother's alibi is somewhat weak. I think additionally, it does not appear as the court has reviewed the affidavits.
We're sort of, so yes, we, like, I will say I have, but but I don't think I can really consider them because they're not actually part of the record. So
Right.
do I have access to them and are they short enough to read at a glance? Yes. And it's, and I think you argued this in your brief, they're not actually before us right now, except in the context of the motion to remand, not in the context of the direct appeal.
Okay. Thank you for clarifying.
Uh-huh.
I also think that even if we did the whole trial again with the
Mhm.
mother as an alibi witness, that defendant still hasn't shown prejudice for her not being part of the trial. And again, as I already said, her affidavit is suspect, does not fully account for her son's, I guess, it doesn't fully account for where her son was that night. Additionally, she would be cross-examined thoroughly about the aspects of the affidavit that indicate she had non-public knowledge regarding the murder. There are details in there that indicate she knew things that were not public at the time that only the police would have known. So I believe that to be problematic. I don't want to repeat myself or my brief, but I believe I've covered most of the reasons why a Ginther on this one alibi issue would not be necessary. Although, you know, if the court believes that it is necessary, obviously we would be happy to have the hearing, bring the mother in, bring Mr. Cheney in, and get their side of the story on the record. Again, it would just be a shame that Attorney Heyman could not appear to defend his work. Your Honors, I did have some argument prepared, but this seems to be a rather inquisitive panel. I don't know if you'd like to just keep going with questions or if you'd like me to address some of my points. I do believe that I've made my best arguments in my brief, and I don't want to repeat knowing that you've all reviewed my brief.
There you go. And I'm guessing the 400 people sitting behind you think the same way.
I believe so too. So unless this panel has any further questions, I would just rely upon my brief.
Well briefed, counsel. Thank you.
It was
Thank you,
very
Your
well.
Honors.
briefed. Rebuttal?
Thank you, Your Honors. Judge Young, you had asked earlier about Mr. Cheney's affidavit, so I did go back and look at it.
So did I. So we're good there. Yeah,
Okay. And my apologies earlier. I didn't want to say something incorrect.
I appreciate that.
Right. And it says I told my trial counsel several times my mother would be an alibi witness for me. My trial counsel told me to contact my mother, but he never did. So that's the extent of the affidavit. So with that, that's all I wanted to clarify.
Okay. Seeing no further questions, this case is submitted. Now calling case number 4-367-344. That's the People of Michigan versus Kendall DeChandre Thornton.
Making a simple correction. I don't blame this housekeeping.
It
When I see Mr. Samad sitting over there, I saw him as well.
It was Kevin. It was Kevin. We know it was Kevin. He always does that. It's always, those ex-state troopers don't know anything.
All right. Helen's not checked in. You think just keep going? Okay. So, appellant is scheduled for oral argument, but not checked in. So we're going to keep going ahead with this case and, Ms. McLaren, right? You can step up and see if we have any questions for you. Thank you.
Janet McLaren on behalf of the people. I also will rely on my brief unless there's questions.
Yeah, honestly, I didn't have any questions on, this was less interesting to me than the 8 or 10. This one. Huh.
I don't think that's how she meant it.
Okay.
I'm
No,
not
that-
offended.
I mean, like legally,
I'm not offended.
yeah,
Thank
sorry.
you so much.
So, but it was very well briefed. You answered all my questions in your brief. There we go.
Yeah, that would have been better.
Yes. There's just so much editing that needs to happen before this goes on YouTube and my reputation's ruined. Calling case number 5370010. People of Michigan versus Barika Butler Quarles. And I have just Mr. Gurwitz for argument.
Good morning. May it please the court. Harold Gurwitz appearing on behalf of Barika Butler Quarles. We have raised issues that arise from the Ginther hearing conducted before the district court over a 2-day period in January of last year. First, it concerns trial counsel's abject failure to investigate. This is a failure to investigate issue and to present evidence of his client's plan to take her own life on August 4, 2021, with a gun that she bought the day before to kill herself and not to harm anyone else. And we argue that counsel's performance was.
So Mr. Gurwitz, let me
Yeah.
jump in. So the trial had evidence of her suicidal ideations. So there's not a complete lack. There's the testimony from her ex saying there were diary entries and that she was having suicidal ideations. And there's the fact that for whatever reason she purchased the gun, she used it against someone else. So the reason for purchasing the gun isn't a factor in the offense. So you can purchase a gun contemplating taking your own life. But then if you use that same gun to assault someone, you've still committed assault.
I don't differ with your analysis, but it doesn't take into account the fact that she had the gun with her on August 4th for the purpose of completing what she began the day before, buying the gun. She bought the gun to shoot herself. The evidence would have shown that that's exactly what she planned to do. Her journal, which was in evidence but never referred to except in a brief reference in closing argument by defense counsel, said specifically, it laid out a plan for her children after her death. It reviewed her financial affairs. And it said specifically, I want to be cremated. Her husband turned it over to the prosecutor, to the police, but it was never referred to at all.
But you said it was in evidence.
It was in evidence. It was exhibits 72 through 77, I believe. And it was an extraordinary piece of evidence which was never used. And that's one of the reasons that we have argued that defense counsel was ineffective.
Isn't that, whether to use that or not, isn't that a strategic decision? I mean, isn't it just, I could see counsel saying it's unbelievable to suggest that the girlfriend or your ex-husband somehow came into his apartment and interrupted her attempt to kill herself in his bathroom and ended up across the hallway shot. I mean, isn't that a strategy for counsel to say, I can't introduce that or make that theory? It's just unbelievable.
You're right that as you've indicated, as the panel has indicated in earlier arguments this morning, strategy is an important part of what the duty of defense counsel is to formulate. But as the court said in Trachtenberg, the Supreme Court said, counsel's unreasonably inadequate investigation caused his failure to present the defense he told the jury it would hear. That's what defense counsel did here. He told the jury an opening statement that they would hear evidence that this event was an accident that was brought about by his client's plan to shoot herself on August 4th. The court in Trachtenberg went on and said his performance was constitutionally deficient because a sound defense strategy cannot follow an incomplete investigation of the case when the decision to forego further investigation was not supported by reasonable professional judgment. And that's exactly what the facts presented at the Ginther hearing showed. There were, I'm sure you've read my long brief with the recitation of those facts, but just to itemize these, I think there are 8 or 9 of them. It begins with his client telling him that the reason she bought the gun was to shoot herself. That's what her testimony was at the Ginther hearing. And he responded in his testimony, counsel did, well, I respected her opinion because she was a psychiatrist and I respected what she had to say about mental health.
Indicating, I suspect that he's not driving the car, she is.
I'm
Which
sorry?
indicating, I suspect, that he's driving the car, not her, relative to legal theories and strategies.
Well, his car went off the road. It didn't quite get there is really what happened, because he didn't understand that evidence of her mental health status was admissible. You know,
Was admitted though.
I'm sorry,
It was admitted. It was admissible and admitted.
but there was more. There was more. He could have presented more. He could have asked questions in cross-examination of Mr. Quarles. He could have called an expert, as we have argued. My client was examined at my request while she was in custody last March by a very qualified professional, Dr. Brooke Lawfer, who was a specialist in women's mental health issues, who concluded that the day that this happened was the day that my client intended to take her own life. And she did that based upon interviews, review of information from the trial record, and psychological testing.
So for failure to call an expert, you also raise an issue with not calling an expert in the construction of the bathroom. So you have 2 experts that you think should have been called. One is a psychologist and one is the bathroom expert.
Well, there's a constellation of evidence that was left out of the presentation by defense counsel relating to the circumstance in which the gun discharged. The judge said he shot her, or she shot him, or her. She shot her. I get the pronouns correct here.
There you go.
But to reach that conclusion, it was necessary to look at the circumstances in the small confines of the bathroom, which defense counsel failed to ever go to, although he was asked to, and there was an arrangement for him to have permission to go to the condominium to have access to the bathroom. The police had a very rudimentary investigation. They had a photo of a hole in a wall that represented what happened. And you couldn't tell, there was no perspective where exactly that was in relation to where the victim testified she was, my client was standing at the time this occurred.
I think what I'm asking is this. In your brief, you raise failure to call an expert with respect to the bathroom as an express issue. With respect to this psychologist, you have placed information about the psychologist as a failure to investigate, not a failure to call an expert.
Well, let me clarify that. I thought it was clear that was the intent of this issue, was to suggest that the psychologist's testimony indicated that professional testimony about her mental health was available to defense counsel before the trial began. And he never pursued it because, as he testified at the hearing, he never looked at the law. He never considered the Supreme Court decision in Kowalski that said that mental health information may be admissible. He obviously never considered this court's opinion in People v. Yost, where the court reversed, where counsel was obviously effective. Counsel investigated and he attempted to present evidence that his client had mental functioning difficulties, where she was charged with the death of her 8-year-old daughter. And the argument was that she didn't do it. That's what defense counsel said. And he called a psychologist and he called his client's other daughter to testify about her status at the time. What the court explained in Yost, I think applies here really very clearly. And that is, the court said Even though the Supreme Court said in Carpenter, People v. Carpenter, in case I'm familiar with, unfortunately, that diminished capacity evidence may not be admissible to show that a person, to negate intent. But the court in Yost said
That it can come in for other reasons.
that it may be admissible for other reasons. That's the essence of it. It says at page 354, but this does not mean that a defendant who is legally sane cannot present evidence that he or she was afflicted with mental disorder or otherwise has a limited mental capability. Counsel never took that into consideration when his client told him that she bought the gun, she wanted to commit suicide. He didn't take that into consideration when prior counsel told him that he had referred the client for examination. He never took it into consideration when his mother, when a client's mother said she was at a low point when this was happening. This failure to investigate is what this is about. And that's what Trachtenberg said. It's a different fact situation, but it certainly fits the circumstance.
So is there any, I understand it's well documented in large part by you, but also a little bit by trial counsel, that she was in active pursuit of ending her life. My question to you is there any expert testimony that says when someone is in active pursuit of ending their life, they are in some way mentally incapable of choosing to shoot someone? Because the reality is there might be abundant evidence that she wanted to end her life. And I don't even take issue with the fact that she's in her husband's home and not in the family home so the kids don't find her. But what I do take issue with is at the end of the day, we end up with someone else shot and her, according to that person's testimony, her in pursuit of them. And I don't see any evidence to say that someone, you know, this isn't, for example, battered women syndrome, which has this documented connection to your mental state, that you're in ongoing trauma. And so at the time you commit an assault, it can be explained or lowered to a lesser offense. There's nothing here to indicate that the same applies to someone who's having suicidal ideations. So I get it. You did a lot more work than trial counsel. This woman was in a state, a really difficult mental state. And that is understating the manner, but I don't see the connection between the elements of the offense for which she is convicted and the defense which you're now pursuing.
I think that you're essentially stating what the trial judge concluded in his opinion on June 27th of last year, when he said, unless defense were claiming an insanity defense, which is not here, as such, any testimony by a mental health professional would not be relevant and admissible. That's conflating what Yost and Kowalski say with what the Supreme Court held in Carpenter about diminished capacity. We're not making an argument there is diminished capacity or a lack of capacity to form the intent. Every one of the offenses with which he was convicted has some requirement for intent. But what we're arguing is that she had a right to present a defense, to tell her story. Her attorney talked her out of it.
My point is, it's not a defense.
I'm sorry?
It is not a defense. That's my point. Suicidal ideations, based on what you have provided, there is nothing, no expert letter, no anything that says that suicidal ideations are a defense to assaulting someone with a deadly weapon and continuing to pursue them.
We have not made that argument that it is a defense. What we have argued is that this gun discharge in the bathroom was an accident. She didn't get an accident instruction because the attorney didn't present enough evidence to support it. It's the result of a mental process which brought her to the point of having a gun, where she was in the small bathroom and surprised by someone coming in who could have never been expected. It could have never been anticipated that this visitor would have come to the third floor bathroom at 8 p.m. on that evening. She wasn't in the house when the client walked in. So the argument is that this was an accident and the evidence of her mental capacity, strike the word capacity, her mental status at the time, was relevant and probative that this was an accident. And it's because of that, Your Honor, that we have argued that both elements of Trachtenberg and Strickland have been established here. Clearly, a counsel was functioning below an objective standard of reasonableness at the time that he failed to do each of these 8 or 9 items to investigate what her status was. And second, there is more than a reasonable probability that the outcome would have been different if he had investigated and presented that evidence. As the court in Trachtenberg said, it is not necessary to prove this by a preponderance of the evidence.
And Mr. Growitz, I'm just going to tell you you have about 1 minute since you're unopposed, but I don't want to, I apologize for interrupting you. I just wanted to make you aware.
I think I didn't cover the arguments in exactly the order that I had intended to present them with regard to both of these issues, but I think I've covered them. This is an extraordinary case where it's a failure to investigate, to present evidence that this gun discharge was an accident, not what she had planned. It never was anticipated that it happened.
How do you marry that with then the fact that she had sent text messages and had this, this emergency with her daughter, like luring him away from his dinner?
That's another example of a reason that evidence about her mental status at the time would have been helpful. She was in an emotional status, as Dr. Laufer said, and that would have explained those messages. It would have explained her behavior in the police car after the arrest. And all of that could have been brought before the jury so they could have had a full picture of what this event was about instead of the limited evidence that they had. Counsel said he was just there to poke holes. Those were his words in the prosecution's case. That's not what a defense should have been about here.
Do you have any questions?
It's always good to see you, counsel, and I appreciate the fact you still talk to me 23 years after I sent you one of your worst clients ever, an elected official. We'll just leave it at that, but
well, it's been a long time, but I appreciate being here as well.
I don't see you as often as I'd like to. It just I really enjoy reading your submissions, and it's an honor. It really is. And
well, I hope that the panel takes all these things that I attempted to say very carefully seriously, because I think my client didn't get a fair trial.
And Mr. Growitz, I just want to echo that you're, as a former public defender, you've obviously been a huge influence in my career as well. So it's a pleasure to see you, and your briefing is incredibly thorough, as was your work in the trial court here. So you've given us something to think about, and you've done a great job for your client.
Thank you, but please do think carefully about these arguments.
Okay.
please say hi to your wife for me, will you? Thank you.
That case is submitted, and we'll now call case number 6370392. This is People of Michigan versus Hong Yuan Lee.
Good morning.
Good morning, Your Honors, and may it please the court. I am Robin Kennedy. I represent Mr. Lee. Your Honors, Mr. Lee has obviously the main issue here in this case is the issue of hearsay. There are just a few things I would like to highlight simply in response to opposing counsel's briefs. They weigh heavily on the argument that the statements made by Detective Garcia were for the effect on the listener. And our position is that is just simply not the case. The statements made during trial by Detective Garcia were the out-of-court statements made by an informant. They were specific statements, including an amount of contraband that this informant would be able to order up.
Well, let me just press back on that a little bit. I don't know, I take your statement as suggesting that was a specific amount. He didn't say specific. He said he could get big amounts. Am I correct? He didn't say, if I go to this, I can get, 10 kilograms. He said I can get big amounts.
He said he could order up a large amount, and I believe also the testimony did indicate that it would be an amount of 10 kilos, 7 to 10 kilos. In addition to that, the identification for Mr. Lee is tied to the phone number. The phone number was specifically provided to law enforcement by the informant, and the informant only was able to identify that individual as a person named Joe. And so the identification, the phone number connected to the phone that was found with Mr. Lee was tied specifically to the hearsay statements provided by the informant. And had those statements not been provided by Detective Garcia, there would have been room for defense counsel to make potential additional arguments. Had the hearsay statements been properly excluded, that the phone was not tied to Mr. Lee. However, it was tied to some individual named Joe. The last thing I would just simply indicate was that in opposing counsel's own brief, they've used the words verify and confirm. The statements were clearly offered to prove the matter asserted, that a large amount could be ordered up, that the phone number attributed to Mr. Lee was in fact going to be Mr. Lee, and that Detective Garcia had to verify those specific statements and then later used another officer to confirm those specific statements as well. So, Your Honors, I would ask that the court consider the statements for what they are. Hearsay offered to prove the truth of the matter asserted, that Mr. Lee is a person who could deliver a large amount of narcotics without having the ability to confront that witness, as Mr. Simpson did not ever testify in any hearing in this trial, at a preliminary exam, at a motion hearing, or at the trial.
So how do you counter the prosecution's argument that, look, the information or the testimony of Garcia was background information to explain why they allow Simpson to make the phone call from jail? That, look, we had him make this call because he claimed he could do this, but we get lied to all the time, is what he said. So we let him make these phone calls to verify that he had a contact that supposedly could deliver up big amounts. Why is that not background information to explain what steps they took in response to a statement?
Because the information that Detective Garcia testified to was very specific. It wasn't simply just generic information where Mr. Simpson said, I can get or where he provided background information as to how they came into contact with Mr. Simpson. And the
tell me what words would have been okay. Like if the detective said, Simpson told me he had a contact that said that he could, I don't know, deliver, just all he could say was drugs, or could he say he could deliver large amounts, small amounts, medium amounts? He could give no descriptor. Is that what you're suggesting?
Yes, that's what I'm suggesting. He couldn't give us any specific indication. He could simply have just indicated that we met with an individual who provided us with additional information and we went out to vet that information. He didn't have to be specific because the statement itself that Mr. Simpson made was an out-of-court statement offered specifically for the truth of the matter of whether or not he could order up a large amount of narcotics from Mr. Lee.
What case do you have that says that specificity is what this court should look like in determining the basis for the offering of a particular statement?
I believe, Your Honor, that was listed in my brief as People versus Chambers, where the statement, the statement is, if the statement is something that is specific, then that was considered inadmissible hearsay. Now in Chambers,
That's what Chambers says? Are you positive that's what Chambers says?
I may be mistaken, Your Honor, but I believe at least in my brief and I know that in Chambers, that was not an issue that changed the outcome in Chambers, but it was addressed, and the specific nature of the statement, the hearsay statement, and again, had it been more generic and simply background information, that would have been something more acceptable, because we may then start moving towards an area where law enforcement are the only people who have to testify at a trial, because everything would be background information. Every piece of information that law enforcement investigates, vets, and receives typically comes from a third party.
I don't have any additional questions right now. We'll hear from brother counsel, and then you'll have a chance for rebuttal.
Thank you.
Good morning, Your Honors. May it please the court, Joshua Miller from the Oakland County Prosecutor's Office Appellate Division. On behalf of the people, we're asking the court to affirm the convictions in this case. The first item I want to address, something that Sister Counsel did not address at all, is that most of the issues that are before the court on appeal are not properly preserved for appellate review. None of the confrontation challenges are preserved. None of the 403 challenges are preserved. And of the alleged hearsay issues, only the first issue about being able to order a larger quantity is preserved. For the reason stated in my brief, the preserved issue, it's exactly offered for the reason that to show why they did what they did. They get this guy who wants to talk to them, says he can do this for them, and it's well, okay, why are we going? You're going to have a jury asking, why on earth did these officers give a man who's in their custody under arrest for drug charges access to his cell phone twice? It's because he said this thing to them. So it is exactly offered for that reason. As to the statements about the background information, it's notable that the detective never actually goes into detail about what was actually said to him. He just said, you know, Mr. Simpson gave us background information about how the transaction we arrested him for went down. We then sent Sergeant Wilson out to look at the videos of this from the security cameras, and it matched what he told us. That's why we were part of why we were willing to trust him to make these calls. As to the issue with the phone number, the case that the defense cited in their brief was an unpublished case, People versus Swift. And it had a very different factual circumstance where you had both the phone number and the contact information that they were looking at and saying, this is how we're making that connection. In this case, we had the detective say, this is the number that was called. We had, by the way, a video of the whole phone call, including them reading the number that was being called into the record that was admitted without any objection. And then later they find the phone, submit it for analysis, and it turns out, oh, that phone number is linked to this phone that was found in the defendant's car when he was arrested. You also have the fact that the defendant, when he was interviewed, admitted his involvement. He tried to minimize his involvement, but he admitted his involvement. He admitted possessing the gun that was found in his car. So there is a lot going on here, but it actually boils down to the very simple point that all of this testimony showed how this conspiracy originated, how it continued, why the officers were allowing Mr. Simpson to work for them. So unless the court has any specific questions for me, I would just rely on my brief.
Nice to see you again.
Likewise. I think this is 3 times this year, I believe, Your Honor.
Well, that's unfortunate for you. Have I ruled against you yet? I'm looking forward to doing that.
Oh, no.
Do you have any questions?
Judge, you wound me.
I don't have any questions. Are you okay? Thank you.
Thank you.
I have nothing additional unless Your Honors have any questions.
Did a nice job for your client. Thank
Yes,
you very much.
Thank you.
Thank you.
That case will be submitted. Now calling case number 7370473. People of Michigan versus Hunter William Locke Hughes.
Morning, Lee Somerville on behalf of Hunter Black Hughes. I just have a question. Do I argue both?
Oh,
briefs
good
at
point.
once?
Okay, yes. So you are both, so Mr. Saman is appellant, that he probably switched the name tags because he is appellant in this case. It was probably him. He snuck in early
I
and
asked him why he was sitting on my side.
exactly,
And
it's because of this case. So, what we'll do, I think, is, you'll both still get, you both get rebuttal, you switch gears, but I think given that this is all one case, if you could just use this opportunity to address all the issues and rather than kind of bifurcate it unnecessarily, I think we can still get this all in within a reasonable amount of time.
Okay. I do too, because primarily I'm going to rely on my brief. Our first issue is judgment of acquittal for child abuse first, because there really wasn't proof beyond a reasonable.
You know,
doubt.
what would help us greatly, candidly, is let's talk about whether whether this confession was properly introduced into evidence. I would, if I was you, that's the issue I would focus on in my oral argument.
Okay, that was two. Yeah, he was interviewed twice. The first time he was taken from the scene, although they said he was not in custody, the testimony of the officer was, I had him transported. And then the second time, which is the one, and I don't think there was a confession in there, but the second time was, they had his phone and they told him he could get his phone back, but he needed to come to the station to do that. They didn't say, we would like you to come down to give another statement. They said, you have to come and get your phone.
Well, police lie all the time, and we consistently say that that's acceptable. The question here, at least to me, seems to be, was your client in custody at the time that the statements were given, either in the first setting or in the second or in both? So I think that's specifically what I would focus on.
Yeah, I would argue both, the first one, because they, they transported him from the scene. They didn't, describe asking him if he would come and give a statement. The officer who testified said, I arranged for him to be transported to the station, but he was not in custody. And they did take his clothes. So they sort of restricted his movement at that point.
Is it okay if I jump in?
Yeah.
Perfect. Okay, so with respect to the first interview, I did not read your brief as advocating that that was at all problematic, probably in part because Mr. Locke Hughes doesn't say much to incriminate himself. As to the second interview, which Judge Borello, I think has asked you to focus on, what I'm particularly interested in is the fact that we have an individual who transported himself to the police station and left himself, or with the help of his stepdad, both which aren't the end all be all, but are two factors that we can, that we weight. Why is that a custodial interrogate? And I think he says multiple times during that interview, very incriminating statements. So why is that a custodial interview, understanding that he came to the police station on his own free will and then was also free to leave?
Well, when I looked at the video, it didn't appear that he was free to leave to me. Just the placement of the people in the room. But you have to consider that he was 19 years old. He had no prior contact with the criminal justice system. you know, he was, this is his first, criminal conviction and first criminal charges.
Is there a case that you could cite to us that we should rely on when making a determination as to whether someone's in custody while being questioned?
You know, they mostly go against me. So I realize that, but I just considering the particular, the particular situation here, he was not asked to come down and give a statement or give an interview or talk to them. They just told him, if you want your phone back, you have to come to the station. So he came to the station. And then they, you know, are trying to get him to agree to all of their statements. And I did note that at the beginning, they would try to get him to agree and say, is that possible? And he'd say, it's possible. Then they said, well, did that happen? And he would say, no. So at some point in the interview, they stopped asking the final question, did that actually happen? And just get him to agree to their possibilities. I mean, he's young, he's inexperienced, and, you know, didn't have any criminal justice contacts before. So he's doing what he's told by these two larger adult men who have him in this little room. And who at the end, I think that the prosecutor in his brief disagreed with this, but at the end, they tell him, oh, we need to keep your phone for evidence still. And they
The
send him
difficulty
away with
we're
no
having
phone.
is that, as Judge Borello hinted at, we need to tether this to legal principles. So as a general matter, for example, I think it's very relevant that this individual was 19. I think it's very relevant that this individual had no prior interactions with the police. However, the case that I have found most relevant, one that Judge Borello wrote, is People v. Barrett. And I don't see where in the factors enumerated there where I can consider those.
Well, one of the things about the second interview, they never told him that he was free to leave. They did at the first interview. They told him he was not under arrest and was free to leave, even though they took his clothes. But they didn't tell him those things at the second one. And it's just, you know, it's just shocking to me that they go to these lengths to avoid explaining to a young man who at this point, they know he has no criminal record and has no prior experience with criminal justice.
Was the door locked at all during I didn't read that in the record.
Yeah, I don't know.
We don't know whether it was locked.
No.
Officers were wearing uniforms or
I
plain
think it was
clothes.
detectives.
Were they armed? Were their guns visible?
I don't remember that detail.
Okay.
But
'Cause those are, to Judge Young's point, those are some of the factors we consider and look at.
yeah. Well, presumably the tape's available. But I do believe that there was one of them who was blocking the door the whole time. Because it was Detective Hill. And then he had invited somebody else come to witness the exchange of property, which never happened and was never going to happen. I just think that under these circumstances with this particular person, that they definitely,
Counsel, if I can interrupt for a second, I just want to stress that when we ask questions, they're not rhetorical and we really do need your help. And for you to answer one of his questions and say the tapes are presumably available, it isn't helpful in this moment. We really do need you to have a grasp on the law to anchor this issue that we've all identified as critically important. And you filed a case raising this issue. And you didn't provide us with the video. We had to independently request those. So I just can't stress enough that I appreciate your being here, but part of you being here is being able to help guide us through this legal analysis. And this is falling short right now.
I just honestly don't remember if they had guns. I don't know whether the door was locked. I just know that a large man was in front of it. And I assume that the video, I mean, there's a court rule saying that you're supposed to file your exhibits with the court so they can be brought up with the record. So that's why I assume that they came up with the record, because they weren't my client's videos. One thing I did want to point out, just
What's your take? What's your understanding of the total time that the interview lasted, the second one, from the moment he walked into the room to the moment he left?
I think it was an hour.
Yeah.
Hour-ish. I know that doesn't help me either, but just the one other thing I wanted to say on the topic of the judgment of acquittal is that the prosecutor's office at trial and in all their arguments say that my client held the child's head under the water. In fact, at the trial, the Detective Hill acknowledged that Mr. Locke Hughes never said that, never agreed with that. And the Dr. Alden, I think, the witness for the defense, said there was no evidence of any injuries related to having his head held underwater. And I think that that this was viewed as a crime early on, in part because of the way the child looked. Everybody thought his head had been, horribly beaten or something. And that was, the ME explained that was not the case. And the mother explained that she always got questioned about the way his head looked. It was just part of this syndrome that he had. So just with respect to the cross appeal, I don't believe that the court abused their discretion in going below the guidelines. Obviously, the guidelines are just guidelines now. They're not the rule. They have to be properly calculated. The trial court specifically said that she considered the chaotic situation that my client walked into, his acceptance of responsibility, his lack of training for care of a 6-year-old with Charge syndrome. And I think very importantly, she considered his age, 19 at the time. And I just mentioned the Taylor case because, the consideration for age in first-degree murder charges now includes 19 and 20-year-olds when you do the Miller evaluation. And he was originally charged with first-degree murder, felony murder, which is the same. So I will just reserve a minute for rebuttal. Okay.
Good morning. May it please the court, Emil Sama on behalf of the people. Jump right into the Miranda question. I believe that's the biggest one we had.
Are you familiar with Barrett?
I am, Your Honor.
There.
And Lewinsky, as Judge Young well knows, as we
Yeah,
were here last
yeah.
time.
Yes.
But this isn't Lewinsky.
No, not at all.
Not just because it's not in a hospital, but because Lewinsky so willingly talked to police. And here, there were initial denials, and then there was more and more questioning, and not open-ended either. Just isn't that right type stuff. So this feels different than Lewinsky in a way that's not helpful to you, and I'm interested in your response.
I will agree. I characterized Lewinsky as basically when he spoke word salad and everything came out at one time. Just a
100%.
flood of information.
Yeah.
But here, I still think you look at the factors, I would submit that you don't have a custodial situation here. You have just one location while it was at the police station. He drove himself there himself. He had his own car. He waited in the lobby. They didn't have him under armed guard in any situation. When he came in.
The police were armed in the.
They did have armed, but they were not in uniform. Yes. And I disagree with the fact that they were blocking the door. The video showed that they were positioned in such a way that the person could leave and come and go if they wanted to. Moreover, the door was not locked. And I saw that from the video because they didn't have to put a key or a special badge. They simply opened the door and could walk out. So the door was not locked in that situation. Moreover, while they did ask questions like, isn't that true? Isn't that fair? Is that possible? It was not exceptionally accusatory. They weren't yelling at him. They weren't trying to overbear his will. It was only a 60-minute interview. And
Yelling is not the only way to overbear someone's
Correct.
will, is that? Okay.
Correct. And I think the question though here is a question of custody.
Right.
We're not really arguing, I don't believe defense counsel has argued voluntariness as an issue, which I think is where age really comes more into play than in the custody factors of Barrett. Age is a question of when you're looking at the voluntariness of the statement overall, whether it was coerced, whether it was overborne. But the issue here is one of custody. And the fact that he was
Young has already agreed with you. She told counsel that's not one of the issues, so.
The free to leave, that was never said to Mr. Locke Hughes.
in the second time, correct.
Right.
First time it was said you can leave when you're free to leave at any time.
And the fact that it was the first time and wasn't the second time is actually worse for you, in my opinion, than just simply never hearing free to leave. Because he has his only experience with police officers. He has been told in one incident in the very same room, you're free to leave. And now the door is shut, the questions are pointed, and he is not informed he's free to leave.
I would respectfully disagree with that. The fact that he wasn't told the second time that you're free to leave, still looking at the other factors, while that could be one fact that would be assistive, it's not necessarily dispositive, especially given that in the first time when he was told he was free to leave, he was actually escorted to the station by the police. He was brought back there with them and they took his clothes. So they did everything to minimize that situation. Here, it's much less than that in this second scenario. He came of himself. He had a stepfather at some point with him. He drove his own car. He was there to get his phone, was escorted back, his clothes were not taken from him, did leave at the end of the interview. And it was short and it was questions that were conversational in its tone. So I think in this situation, I think you have less of a concern of this person wouldn't feel free to leave as you did in the first interview where he was brought, they took his clothes and he was in there. So I think the assurance of the detective in that situation, the first interview was, you are free to leave, even though we know we're taking all this stuff, we're not holding you. In the second interview, thank you for coming in. You were in the lobby, come on back with us. Let me ask you a few questions and then you're free to leave.
Am I correct in my recollection of the record? Forgive me if I'm wrong, but he was driven there with his stepfather and then the stepfather stayed in the lobby and he was brought back by himself. Is that this case? Am I remembering that correctly?
I know the stepfather was there. I'm not sure exactly how they got there, if they came together, if they met each other. I
But
believe they did.
stepdad was never in the room.
But he was
with them.
not included to come into the room.
Correct.
Which doesn't that suggest then it's more of an interrogation?
No,
As opposed if they had the stepfather in there. I mean, he's of the age, they don't have to, but if it wasn't an interrogation, the father could have come back if they've just had some clarifying questions and to turn over the phone.
Well, I think that has to do, there are a lot of different ways that could have gone in. The fact that you could have brought your whole family with you. Not all of them are going back into the back of a secured police station, respectfully.
They
even with
are
the
if they're
stepfather.
Sicilians.
That's true. Or Lebanese, and everybody goes together. But in this situation, I don't believe that is dispositive either. He was in the lobby. They said, come on back. And then even if they were,
you referenced secured police station, right? So what, he had to come back. I assume he had to go through metal detectors.
no,
No metal detectors?
Shelby Township does not have a metal detector.
Okay. But it's still a secured police
Right, a
station. to
police
use your
station is
words.
Yeah,
custodial.
to go into the back area where the police officers are, there's going to be a locked door. You're going to have to go in there with that person, not to leave. To leave, you can just walk out. To go in, you need the locked door. And I know that's not part of the record. That's me
Understood.
being in Shelby Township all the time. So, but
We won't ask why.
I didn't do it.
So the location of the questioning, custodial. It's a police station.
The police station by itself does not necessarily make it custodial. While the location does tend to do that, the fact that it's in a police station by itself, I don't think it's just positive that's custodial of itself, right? And we've talked about this before, and we've had case law where you could be in the middle of a police station and not necessarily custodial. You could be in the middle of your house and be in custody.
So there's a difference, you admit then there's a difference between the police coming out, he's in the lobby. If it's just to give the phone, they could have said, hey, here's your phone. Oh, by the way, while you're here, I got a couple of questions for you. That is a different case than, hey, come on back through the secured door. I've got to badge you through. Then we take you to an interrogation room. We shut the door. Another officer comes in. That's distinctly different than, say, a questioning that takes place in the lobby of a police station. Would you agree with that?
Sure, yes, in the back versus in the lobby, yes, it's very different.
Okay, and what we're dealing with here is in the back, which strongly suggests custodial environment.
I think it would only go to the first factor of location. I don't think it goes to the other four
Right,
factors that
so
that apply
location,
here.
custodial, duration, neutral or not custodial, citing Lewinsky, because I think Lewinsky was about the same time
And
frame.
even Bear, and I think even Bear was 90 minutes and this is, again,
Okay.
15 minutes.
So statements made during the interview, I think custodial. They're incredibly incriminating against Locke Hughes, and the way that the police talked to him was increasingly more aggressive. Accusatory, thank you. That's a much better word, because there isn't aggression. There is an absence of aggression, but it is accusatory. At one point, I think they say he'll feel like a monster if he doesn't confess. So talk to me about the questioning.
I agree that it was not aggressive in any way, shape, or
Yes.
form. I think it was questioning. I think they were asking pointed questions because the original statements that were given and the evidence that they came to, they needed to clear up some information. I don't think that this is the kind of accusatory or overly aggressive questioning that would make it such a way to make it in custody or make it custodial in nature. In this situation, they were asking questions and they were trying to follow up and get to more, and they felt like he was holding back and they were trying to get to that. If they truly felt that this was the kind of situation, that this was an accusatory situation, I think they would not have allowed him to leave at the end of this. But in the interim, you did not have them yelling at him. They weren't cursing. They weren't calling him a liar or disbelieving him. They did say,
I think they very clearly were disbelieving him.
They were, yes, but they weren't calling him a liar or saying you're lying to me. I think there were some cases like People v. Stewart where they were extremely like you're a lying and they cursed at him multiple times. But
Right.
Is there,
That's
is there like magic words that the police have to say to hit that? I mean,
I don't
they
think
have
there's
to-
any, I think it has to go overall with the overall tone and the overall everything, when you take it together in the totality of circumstances. So I think in the totality here, really, we're questioning about what they said. I'm sorry, not what they said, but how they said it. And while how they said it is important, what they said was, what about this? Is it possible? Could this have happened? Because we're having trouble gelling these situations together. Not you're lying to me, come forward, you're not leaving here until you tell me. I think based upon when the video is watched, it does not come to that level of so accusatory, so much to render this in custody. So I respectfully disagree that it's custodial.
Okay, so here's a quote from one of the officers. That's not what happened, and you know that's not what happened. And then an additional quote is, if you don't confess, you'll be portrayed as a monster. I guess I understand their tone and name calling is distinct from Stewart for sure, but it remains true that despite their calm demeanor, they did not for 1 second accept any version of events other than him admitting that he did something wrong.
But and I'm only remembering those two statements that you've just said. I'm trying to remember if there were more than that, but in a 60-minute interview, two statements, especially with regard to, I believe the questioning was, that the 23-month-old is the one that drowned the child, and then he finally backtracked, said, okay, no, she had nothing to do with it. right? So I mean, if I tell you my 23-month-old is the one that killed my child, and you said that doesn't sound plausible, I don't believe that, nobody believes that, and I say, okay, you're right, it didn't happen. I don't think that's going to raise it to the level of now it's custodial. Now we have lifted that line, the custodial.
Did the addition of saying, you know, you'll have to seek forgiveness from God and bringing that into the scene, did that make it sufficiently accusatory to rise to the level of a custodial environment?
I would submit it to not.
Let me ask you a different question. Let's say we're not with you. Let's say we're not, but we're peppering you with all these questions. Let's say that's where we land. Is that game over, or can you still establish, look, yes, that second interview will concede, not that you are conceding, I'm not suggesting that, but yes, should have been Mirandized, those statements come out. Is that end of story then, and we vacate?
I don't believe so. I
Okay.
believe it
Tell
was
me
already, I believe it was already established multiple evidence here that the only people in the house was him and her. The statements at the scene of the defendant and the child in the tub and the 23-month-old being there, the phone call that was going on around the same time with the mother in that situation, the EMT testimony of, especially with regard to the judgment of acquittal, was that this child, who said had been down for only 5 minutes, started to have a rigid jaw and should have been resuscitated with only a 5-minute drowning. This was not consistent with a 5-minute drowning. I think when you bring on all that stuff, even though it would have been more difficult, it would not have made the overall difference in the situation, especially with regard to the fact that they found it involuntary manslaughter on the one and then child abuse first on the other. I don't believe that the statements with regard to the murder manslaughter really would, I don't think it helped or hurt him. It seemed to help him more because they still went involuntary manslaughter with the homicide part of it. So I don't believe that this, even if we get past the Barrett factors and we also find that this is an overly coercive environment, then even then I believe even removing them will not require a new trial.
If I could shift gears real quickly here and just ask you one quick question. I don't fully grasp what the prosecutor's theory was here at trial. Was that the defendant drowned the child?
Yes,
Okay.
that was the theory we argued for the felony murder, that he held him down under the water out of frustration, anger, whatever it was. In any way, shape, or form, it was the holding down of the child under the water. Whereas the defendant's argument was the child got back into the tub, I don't know how, and he accidentally drowned, which is what we were obviously completely disagreed with and argued against it based upon all the evidence that we had from the mother, the EMTs, and the medical people. So in that situation, yes, our argument was he drowned it, which I think goes to the inconsistency argument made. It is not truly inconsistent. They could find that he may have tried to hold him down, but did not have one of the 3 elements of intent to kill or intent to do great bodily harm, but potentially just restrain the child, and the child died. So I don't think it's inconsistent to have a child abuse first degree and an involuntary manslaughter under these specific facts.
Thank you.
Now,
And then we talked about being 19, whether it's something that they can consider during the Barrett analysis, but it's definitely something that they can that the judge can consider at sentencing, regardless of the conviction you face. It's not only first degree murder convictions where the fact that someone's 19 with no prior history with the police is relevant. So what's the problem with the sentence?
because she never thought it was never based upon his age. Really, the judge's argument for the departure, the extreme departure below the guidelines, had to do with his expression of remorse, which I did contest, but let's take that as the judge accepted that as an expression of remorse, right? The fact that he had no criminal history and nothing else in his OVs or PRVs are accounted for in the OVs and PR, or specifically the PRVs of this thing. The judge made no inclination or explanation of why it wasn't given enough weight with this specific defendant. Really, what the judge's basis was not his age, was not the lack of criminal history. It was the fact that she was trying to mesh the verdicts of the jury from child abuse first degree, and involuntary manslaughter. And because they had this kind of verdict, I believe the jury wanted this, and this is why I'm going to do this guideline. And that is an extremely dangerous proposition for any court to take. Because if we start trying to go into the head of the jury of why they came out with this decision, and then try to use that to fashion our sentences, it abdicates really the role of the judiciary in the idea that we will never know what the jury thinks. They are not held to any rules of conduct or consistency. They can do whatever they want for whatever reason, as long as it's not very specific sets that would make it an exception. In this situation, the judge is trying to get into the head of the jury, say, because of these inconsistencies, I'm going to go ahead and go below the guidelines on this charge because I believe that's what the jury would want. What the jury want, frankly, and pardon my language, I don't give a damn because it has nothing to do with what the jury wants.
Right, but there's the reality of the conviction.
And
So
the
it's an
conviction-
involuntary manslaughter conviction. The court acknowledges that and then says they did not believe it rose to the level of intentional, but somehow recklessly negligent. The court's taking that into consideration as they must, because you have to be sentenced on the offense for which you were convicted.
Yes, that's the involuntary manslaughter, but here they were sentenced on the child abuse first degree, and the child abuse first degree had a much higher guideline. The fact that they came back guilty on a lesser included they did not come back guilty anything different than child abuse first, and they could have found not guilty if they truly believed it was an accident, the way they did with involuntary manslaughter. They didn't. They came back with guilty of child abuse first degree because they didn't believe it was simply an omission or the child got back in the tub. That we can at least potentially see that, but to then try to determine that our sentence should be on the fact that the jury obviously didn't believe this part, but it took nothing into account that they obviously found he was guilty of child abuse first. And instead of addressing that situation or explaining how that was improper based upon the PRVs or the OVs, she used the inconsistency as a basis to depart below the guidelines. I cannot say that that would be a fair in any way, shape, or form for either side. It would be like almost a reverse bet that we're saying because they acquitted of this, we should take it into account when lowering the guidelines. I don't think we should have a reverse bet. So therefore, I believe that at the very least, a remand would be to better articulate what her basis for sentencing was, and it can't be on the fact of a reverse bet argument.
There's always excellent arguments, counsel.
Thank you, Your Honor.
Enjoy having you in our court.
I try,
really do.
no matter where I
Not
sit.
leaving, so
Well,
don't butter him up too much.
The next one is really not that interesting to me. Thank you.
Thank you.
I just wanted to mention that I don't think that the judge came up with the consideration of, sort of meshing the two offenses. That was something that defense counsel said. He said, well, I think you should go between the two guidelines. So that was something defense counsel said, and I think that the judge did articulate plenty of reasons for going below, and I think there are plenty of reasons for going below. That's all my rebuttal.
And then you technically get a rebuttal just on the sentencing issue as appellant.
She just did it.
No, he does.
He doesn't need rebuttal.
Okay. Yes. Okay. All right, this case will be submitted. Now calling case 8 on the docket, number 374013. This is People of Michigan versus Moses Richard Emanuel.
Good morning, Suzanne Gabar on behalf of Mr. Moses Emanuel. For my oral argument, I'm going to focus on my opposing counsel's argument as to why PRV1 should be scored. And when he says in his brief, because the federal conviction in this case has a punishment of maximum of 20 years, we should automatically score it. I believe this is an incorrect analysis because if you look at the statute, subsection D, which the court relied on and opposing counsel is relying on, it says if we can't match the out-of-state conviction or the federal conviction with a state offense from M2 through H, and this is punishable by a maximum terms of 10 years or more, then you score it. So the word "and" is very critical here because you can't just say, okay, it's 20 years, we're going to score it. And I want to focus on two cases. One that did score PRV1, but I think it supports my argument, and that's People versus Cruz. It's cited in my brief because in that case, there was an Ohio conviction with a penalty of 8 years. And the court in Cruz said, well, we need to look at the statute to see if it corresponds to a Michigan equivalent. This was a second degree burglary, Ohio, and the court went through the elements analysis, and they found it to be equivalent of second degree home invasion, making it a Class C felony scorable under PRV 1. So that supports my contention that you can't look just at the sentence. And in that case, it didn't match the end because you had a corresponding statute.
But you said that was an 8-year, not
It was
a
an
10-year.
8-year. Yes. So if we were to follow Mr. Samal's argument, then he would say, oh, we don't score it, right? But that's
Oh, I
not
see
the
what you're saying.
analysis. I'm saying
Okay.
that even though it got scored, it's following my analysis. You
But
need-
doesn't that undermine the power of the word and?
It does not, because there was a corresponding statute. The statute says it does not correspond and it's more.
Oh,
So there
got it.
was a
Okay.
corresponding
Got it.
statute.
Okay.
And the second case that also supports my argument is People versus Reynolds. That case, there was a felony conviction for counterfeiting, a federal conviction, very similar to the one here, where the maximum penalty was 20 years. The same argument was made that I'm making here. Well, you can't just look at the punishment. They found it to be, in that case, they found a corresponding statute of uttering counterfeit notes, which is a low severity felony. And they remanded the case for scoring it under PRV 2 rather than PRV 1. Again, supporting my argument that you can't just alone look at the punishment. And it's very much outlined in both cases. Ironically, the one with the lower scores it under PRV 1 and the one with the higher. But I think they support my argument is you need to go through the corresponding analysis. And I did that in my brief on page 8, where I found 2 Michigan statutes that basically correspond to a Class E felony with Mr. Moses.
Yeah, counsel, thank you for that. And I thought your analysis on that was very well done and understood it completely. One hurdle I'm struggling to get past and help me understand is there was an objection to the scoring at the trial level on PRV 1, and it seemed to be as if there was an agreement that it should be scored at 25. How does that agreement at the trial court level not result in a waiver of that issue here? How do we get to all your, let's say, good analysis on the cases and all of that? That's where I struggle. How do we confront that waiver?
I believe the fact that counsel objected to PRV 1 in general does not waive the fact that this cannot be argued in this stage, because there was an objection to PRV 1. It was an incorrect analysis as to the number of prior high severity felonies because they got reduced to 1, being the one I'm arguing now. But I think the fact that he made the objection doesn't waive it. However, even if this court were deemed that there was no objection.
Finish that, and then I got a question for you.
People versus Crane would still allow you to make the review under plain error. And I think that because this error is so obvious and affected his substantial rights, because recalculation would move him to a from D to C, that I think even under the plain error review, I would still win.
But for plain error wouldn't apply to waiver. It would apply to forfeiture. And here we're talking about waiver. So seemingly the only route around that is ineffective assistance of counsel.
But I think that counsel still, I'm saying that there was an objection.
Okay.
But it's the objection itself if the argument is, oh, well, he didn't object specifically to this one. And I am going to cite, I don't believe this case is in my brief.
That's what I was going to ask you. That's where I was going is, do you have a case to support your
So,
first
well,
point about
it's
the general objection at any stage preserves it at appeal, even if at trial they agree that or accept the 25 and don't renew an objection after it's scored at 25, which I think is the case here.
So
And I'm sure you'll
this
clarify
case
that for me.
doesn't say general objection, but I think the way the court states in it, and it's People versus Damien. I'm trying to find the site for it. I pulled it up while I was waiting because I had a feeling you were going to ask about a case, and it's a docket number 370660, June 13, 2025.
Can you
But-
slow down 1 second? I
Oh,
write
sorry.
slower than you talk.
People versus Damian Banks.
Yep.
June 13, 2025 case, docket number 37660. Now, it doesn't address what you're saying specifically, but it says defendant preserved his arguments by objecting to his scores of OV3 and OV10 score in the trial court on the same grounds that are now asserted in his appeal. So it says on the same ground, but it also says there is an objection. And then talks about the the clear error. So the reason I'm citing to this case, because there was an objection to here, it was an OV. In my case, it was a PRV. I think the fact that he objected to it is does not waive the objection.
So stating it differently, we would be holding that defense counsel doesn't need to renew an objection after a new score is set on a PRV or I suppose an OV.
Yes, because I think he picked there also two evils for one, and two, it's the burden of the prosecutor by preponderance of the evidence to prove the scoring of the guidelines. The objection was made. I don't think that burden was also met. And I think the court also was required to do that element analysis, the corresponding analysis, and that wasn't done here. By doing the objection, preserved the issue, and the rest kind of fell apart because the rule was not properly followed by doing the element analysis like it was done in Cruz, like it was done in Reynolds. I don't have anything else if you don't have any other questions.
No.
Okay.
Anything else on behalf of the people? I really want to rest in my brief when it comes to the specific statutory construction of the PRV. I really want to address the waiver argument. And the reason why I want to address it is I did not argue waiver in my, I'm sorry.
You said the reason I really want to address it, I said, is because we asked.
Yeah, and
Yeah.
and because I did not address it in my brief and I don't want to address it in my brief. And I know that it could be a potential winning argument for me. However, I also look at the reality of the situation that even if he were to argue and find that the issue was waived because of what he did, I am then faced with the inevitable motion for relief from judgment argument on an ineffective assistance claim and that the sentence was invalid.
And to be fair, it doesn't, the actual that's an accurate relaying of what happened, but there's nothing to say, there's no like affirmative agreement reached between the two. So it may not even have been waiver, at least in my reading.
And even if it was, I think that the court, under its rules and the inherent powers of the court, can also raise the issue if it's glaring in front of them the way, the courts have done as well as the Supreme Court has done. I think it should address it even on the consideration of ineffective assistance if it comes into, because really the issue here is under the statutory construction, does this apply? Is her reading correct or is my reading correct? And her reading is excellent on that note. So I would rest on my brief on that issue. And if you determine that whichever reading's correct, ineffective really doesn't matter. If I'm correct, then there's no prejudice and we're good with where we are. If it's incorrect, then whether it's a waiver or it's ineffective assistance, a resentencing is required. So that is my position at this time.
Well stated.
Yep.
Thank you.
Anything?
No.
Anything? No. Okay.
Thank you,
Any
counsel.
rebuttal?
Just one.
Okay.
Thank you.
Gave you.
He gave it to me.
I'm
I
gonna
just want to say.
rebut my client getting to
No.
hear this issue.
I just want to say, he said either my reading or her reading, and her reading is correct. It's because of the end. That's why my reading is different.
Yeah.
I have to say that. I can't give him the last word.
I appreciate a last worder. Thank you. Thank you. This case is submitted. Now calling case number 9-371-259. This is Maha Chidiak versus Najee Chidiak. And we do have one counsel for one party appearing remotely.
Next time, Mr. Seaman, I'll have you bring me cannolis from Vince and Joe's.
Hi.
Good
Mr.
morning,
Falk, can you hear and see us?
I can. I hope you can hear me.
Yes, we can. And you were just about to introduce yourself, so I'll let you take it away.
Okay, thank you very much. Yes, Alan Falk on behalf of Najee Chidiak, the defendant appellant in this divorce matter. As the court is well aware, this case went to arbitration, and on appeal from arbitration or even at the trial level, the arbitrator's findings of fact are not reviewable in any way, shape, or form. But in this case, the arbitrator made a number of legal rulings that are, on the face of the record, are clearly erroneous. So the first issue has to do with my client's claim to having essentially a 25% interest in his ex-wife's dental practice, which arose because he provided all kinds of business services over the course of many years.
Yeah, so
10 of those years were.
let me ask you about that argument.
Sure,
So,
please.
at one point in page 18 or 19 of the arbitration agreement, the arbitrator says, for reasons to do with common law marriage, we can't look at your contributions prior to the marriage, which is not true because unmarried parties can contract and it doesn't make it a common law marriage or anything like that. So that was a misstatement of law. The difficulty I'm having is the arbitrator was not presented with this Featherston argument that you can recover on an agreement that's express or implied in fact. And so even though there's a legal error that you can't recover at all because of a misapplication of common law marriage stuff, you never presented, you or your client rather never presented the arbitrator with this argument. So given how cabined we are in our review, how do we overcome that?
An excellent question, Your Honor, and I thank you for it. I think the straightforward answer to that is that the case law is clear. I'll cite Kitchen v. Kitchen, a Michigan Supreme Court case. I don't have the site off the volume number off the top of my head, but in Kitchen v. Kitchen, the Supreme Court says, once you've preserved an issue, you can make a better argument on appeal than you made at the trial level.
And I think that's really true, but I'm not convinced that's readily applicable in the context of arbitration agreements.
Well, of course, we also claimed an express contract based on the October 16, 2015 email in which.
Go ahead.
Yeah, in which the plaintiff wife, says or, proposes that the value of my client's contribution to the dental practice is 25%.
Let me ask you about that, because doesn't the arbitrator's opinion expressly say, I don't find the elements of a contract, i.e. an express contract? In the email you're referencing was an email she sent to herself and then is forwarded from her account to her husband's account. And the testimony at trial was that she didn't send it to him. He sent it to himself from her email account. That's my recollection of the record. Am I wrong about that?
You are not incorrect, Your Honor, but my point would be the arbitrator didn't reject that as being a contract on the grounds that she never sent it to my client. Okay, he never found it to be true, her claim that she didn't send it to my client.
Well, but she said, the arbitrator said, I don't find the elements of a contract here, and then goes on to make other statements that I think
but
that Judge Young was referencing that contain incorrect statements of law. But there is that specific finding of essentially no express contract, which my next question would be is, that leaves you with your theory of implied contract, correct? An implied fact contract.
Yes, or a contract created by performance on both sides.
And just to carry that thought forward, then, isn't under Michigan law an implied in fact or an implied in conduct contract a factual determination? That it is a question for the jury under Michigan law whether the conduct or the facts support a finding of a contract. which I guess you can guess my next question then. Doesn't that fall into the area of it was a finding of fact by the arbitrator that we can't review?
No, Your Honor, I would not agree with that because at worst, from my perspective, it would be a mixed finding of fact and law.
Okay.
Right? Because the arbitrator basically, if he thinks my client hasn't done all this work that my client has claimed, he could have just said that, and then he wouldn't have had to get into any discussion of contract, whether the email is a contract, whether anything is a contract, because he could just say, oh, well, the plaintiff denigrated the value of my client's contributions to the business. Okay, so if he believed that my client's contribution was essentially de minimis, as plaintiff claimed, that would have ended the matter. He could have just said, yeah, whatever you did, it just wasn't enough to matter to give you some kind of an interest in this enterprise. And he didn't make that finding. So, and instead he went into the other discussions of, it's not, this particular document isn't a contract, but it can evidence our agreement as to part of what the contract is. That is, say, 25% value for your contributions. And then, as pointed out in our brief, when you have an arrangement or an implied in fact contract by performance, so one side says, if you do thus and so, I'll compensate you in a certain way. And the other side then performs, and the first side accepts the performance, which is certainly, I think, undisputed here. You can't then, and now we're left with the fact. So the arbitrator agreed all that happened and then says, well, my client gets basically nothing out of it. He only gets the increase in value from the time of marriage to the time of divorce. And
but he
not,
was
not even that.
Didn't the arbitrator also find he was compensated for some of his time? I think $800 weekly or biweekly.
I think it was $400 biweekly, which came to.
Let me ask a question related to this. So, okay, so we have an error of law with respect to the application of common law marriage principles, and I think also with the statute of frauds. There's a finding of no express contract. That's what you mentioned.
Yeah.
Which leaves open or absent the finding that you have identified as a mixed question of fact and law about an implied in fact contract. Okay. So,
yes.
So there's an absence. So the first question is the absence of a legal finding the same enough to reach the very high bar, that we are faced with in reviewing an arbitration award? Because it's not the same as an error it's not necessarily the same as an error on the face of the judgment that affects the outcome. And the second thing is, even if you argue it is the same as a legal error on the face, what do we do with the fact, as Judge Trebilcock just pointed out, that ultimately she concludes, so there's this litany of, or grouping of legal errors, but ultimately she concludes, quote, husband was compensated for his work related to the dental practices prior to the marriage, end quote. So there's a bunch of contractual stuff that's messed up, but at the end of the day, the arbitrator made a factual finding that we can't disturb. That sort of, I don't want to say remedies the potential issue here, but makes it such that we don't actually have anything we can revisit.
Oh, another excellent question, Your Honor. And if I'd like to answer it by saying that the compensation is supposedly $400 biweekly that she paid him, for which there is no documented evidence. But more importantly, if this was compensation, she never reported it either on Form 1099 or on a W-2 to Uncle Sam. She would have had to pay Social Security tax on it. Well, if it was a 1099, she wouldn't have had to pay Social Security, I suppose. It would have been non-employee compensation. But
those are all great arguments to the arbitrator, but the arbitrator heard a lot of that and said, sorry, I don't agree with that. I find he was compensated.
Well, but it's the wrongful conduct rule, Your Honor. She's cheating she's cheating federal and state tax authorities because one of them has to pay income tax on this money. And she's saying, okay, even though I cheated the tax man, I want you in an equity proceeding to give me credit for this.
So just to say back, you're saying that the wrongful conduct in reference to the DRAA is not wrongful conduct related to the arbitration, but it's because you think her testimony was essentially untruthful. And isn't that what you're saying? You're saying
No. I'm saying, let's accept that she's telling the truth, but then she's committed and she's now relying on an illegal act to gain credit in a court of equity, which you can't do, right? If a transaction is tainted with unclean hands, a court of equity closes its doors. That's Stashnik versus Winkle, among others. So again, it would be a legal error for the arbitrator acting in equity to grant credit for that, as she has claimed it. Right? I mean, she can't have it both ways. If it was compensation, then she had to report it, and we would have had some documentation of it. The fact there's no documentation, suggests to us, a problem. But either way, I don't want you to second guess the truth of the arbitrator's finding that she paid this money. I'm saying, though, that it can't be credited for this purpose, because if it were, it would be compensation. It makes more sense to credit this money as an allowance, right? Because they're living together, they're not married, and somebody's paying the landlord, somebody's paying the utilities, somebody's paying the cable bill, and how they're dividing those costs between them. A $400 payment per month, might be a fair estimate of her share of some part of those obligations, rather than as compensation for actual work performed. So I'm not doubting that she paid the money. I'm only doubting the characterization that it represents compensation, especially because suddenly when they're married, the compensation goes from $400 biweekly, which is a little over $10,000 a year, to $31,200 a year, 3 times as much. So how did it? And she says this is when he starts doing less. According to her, he's doing less than he did before. So why is he making 3 times as much money for, when he's doing less work? That doesn't make any sense to me. So, that's my response to that. So obviously, the panel is, read my brief. You've understood my arguments. I had a lot of other things I was going to say. I do just want to say give you one citation, because this is not in my brief. And it has to do with this mixed question of law and fact. When there's a mixed question of law and fact, that's reviewed de novo like a question of law. And the citation for that would be Johnson versus Harnischfeger Corporation. It's 414 Michigan, page 102 at page 121. So just so you know, I'm not talking through my hat, at least on that point. Does the court have any further questions for me?
Anything?
No, and you have some time for rebuttal.
Yes, thank you very much, Your Honor.
Morning, Your Honors. May it please the court, Sam Vitale on behalf of the plaintiff appellee Maha Chidiak in this matter.
Is this case ever going to end?
I certainly hope so, Your Honor.
This is why people hate lawyers. I'm just going to be very blunt.
I couldn't agree more, Your Honor. We're the appellee here. I mean, we're now long past the point where this litigation has outlasted the length of the marriage. The defendant is asking the court to do exactly what decades of jurisprudence say that the court can't do, which is to reverse the factual findings of an arbitrator. The factual findings that were reached after 10 days of testimony and voluminous evidence.
It's not just reversing. Well, I don't read it as just asking to reverse factual findings, which I agree can't be done. But what do we do about the fact that there are legal errors on the face of the arbitration agreement?
Well,
Arbitration award. Thank you.
yes, Your Honor. So to the extent that the arbitrator did misstate some conclusions of law, I think in the arbitration award, I don't think that they were dispositive, and I don't believe that they were. I believe any of those errors would be harmless. And as the court recognized, she specifically stated that he was compensated for his contributions to the business. She specifically stated that there was no element that the elements of a contract were not established. And while I understand that her statement regarding common law was not necessarily applicable in this situation, just after that, she notes that the court in a divorce matter, which is all this was, is required to look at the period of the marriage, not starting before the marriage. There was no breach of contract claim here. There was no unjust enrichment claim. That wasn't litigated before the arbitrator. The only thing we litigated before the arbitrator was whether his contributions to the business granted him more than just his marital interest in the business. And
she made a finding.
She made a finding that he provided no substantive evidence to support his testimony that he was involved in the business, that that wife testified in opposition to his testimony. She also had her office manager, who had been employed for the entirety of this time, testify that she didn't see him in the office. She admitted he made bank runs with money from he did some payroll work from home. It was a few hours a week. He did receive a salary. For a while, it was paid by W-2. Prior to that, it was just paid directly. This was a boyfriend and girlfriend at the time who were living together, and she transferred money to him by Zelle. The issue of whether or not my client complied with the tax code in doing that wasn't before the arbitrator. It was whether or not these contributions were compensated or whether he deserved compensation for these premarital contributions. And the arbitrator very clearly made a factual finding on that issue that he was compensated.
And didn't feel the need to compensate him fuller, or made the mistake of saying, because this occurred before the marriage, I can't compensate you additionally. That seems to be what my two colleagues are hung up on here.
I'm not sure I understand.
Their contention, as I understand it, is that because the arbitrator in this case made a misstatement of law, that prohibited her from adequately granting unto the husband what would have been fair compensation that he would have otherwise been entitled to. Well, regardless of her statement that he was compensated, the next step should have been, was he adequately or was he fairly compensated, right?
I don't think it should have been, Your Honor, because frankly, that wasn't before the arbitrator. I mean, this was a divorce case. The arbitrator was tasked with making a determination of separate and marital property and dividing the marital property. She did that properly. She found that the premarital interest in this business was separate property, and she granted him half of the marital interest. So it's not like he was completely cut out of this. I mean, this was a 3-year marriage for a business that existed 3 years before, or I think even more than that, years before the marriage took place, and he still got 50% of the marital interest in the property. Now, whether or not he performed work that he should have been compensated for, I guess he could bring an unjust enrichment claim against her for that, but he didn't. That wasn't before the arbitrator, and it wasn't really raised at all until now.
Thank you.
And the same is true with the contract or the implied in fact contract.
Absolutely. I mean, the facts of that were certainly discussed during the arbitration.
But not that theory.
But not the contract theory, right? They were simply a way for him to try to invade her premarital assets.
Right. And so let me just clarify with respect to arbitration agreements, the failure to raise a particular argument ordinarily in this court doesn't preclude us considering it. However, the failure to raise a particular argument in arbitration does preclude us from considering it.
I'm not sure that you're necessarily precluded. You could still address it if it were to be a manifest injustice. But in general, the fact that this was not raised before the arbitrator and they were required to raise it at a time where my client could provide some factual and legal rebuttal to that argument. They didn't do so. They didn't do it in the motion to vacate the arbitration award. It didn't come up until now.
Thank you.
Thank you.
Anything further?
Yeah.
Didn't mean to cut you off.
Yeah. I was just thanking you for answering the question. Not just
Absolutely,
like
yes.
totally. Yeah.
Just
Candidly, that seems to be the only issue we're hung up on, so.
Understood, Your Honor. Then I will rest on that if unless you have any further questions on the valuation or anything.
No, thank you very much.
Thank you. And Mr. Falk, you have some time for rebuttal.
Yes, thank you, Your Honor.
Mr.
Couple
Falk,
things.
I'm going to interrupt you here for a second, just to give me
Please.
some idea what we're dealing with here. Let's suppose that we agree with your argument that your client was not adequately compensated for his marital services. Best case scenario, what are we talking about in terms of an award?
I think his claim would be for about 25%. Probably based on that October 16th, 2015 email.
25% of the valuation of the business?
Yes.
Okay. So that would be about how much?
Well, it depends. Well, all right. The arbitrator accepted plaintiff's experts finding a premarital valuation at 322,000 and some dollars, I believe, is the number. So we're talking that would be $80,000.
Okay. Thank you.
Yeah, no problem. Let me correct a couple of statements that opposing counsel made. First, he said that the appeal has lasted, longer than the marriage. That's not correct. As they pointed out in their own brief, and as the arbitrator specifically noted, a marriage ends when a judgment of divorce is entered. Here, the judgment of divorce was entered May 22, 2024. And the marriage was in October of 2018. So that's just under 6 years, and we're just over 2 years. Most of which we've been waiting for oral argument. I didn't seek any extensions of time for any part of my contribution to this appeal.
Well, the reason I say it, and you probably shouldn't have woken the bear on this one, but now that you have, your clients both decided not to try this case in front of a judge, but to go to a private individual, to pay that individual to render a verdict. The theory here is by doing so, we're gonna shortcut all of this nonsense with these judges. Well, what it does, and this has been my 23 years on the bench, so the arbitrator rules, then you go to the judge who initially should have heard the case, and you argue, well, the arbitrator was wrong, and blah, blah, blah. Then when the judge issues a ruling, you come to the Court of Appeals. And then if you're lucky, as in this case, the Court of Appeals sends it back to the arbitrator. And then after the arbitrator rules again, then you go to the judge again. So that's, I think, what frustrates the living daylights out of people is when you tell them, hey, we have this different way of doing it and it's going to short circuit how long this takes, and it actually makes it longer. I think that's what causes a lot of consternation towards our profession. And that's my take on
it. If it were in my power, Your Honor, to cure all the ills of my profession, I would be the first to volunteer.
Counsel, let me ask you just one question and follow up. I guess, you agree that under the DRA, it's very limited review we have, right?
Yes, I do.
And there's 4 subparts under which it is. What subpart are you saying this lack of credit for premarital contribution and the error law falls under? Is it subpart A, B, C, or D?
I'm afraid I don't know which A, B, C, and D you're referring to. Are you referring to some section of the statute?
Yeah, MCL 600.55081 sets forth very limited circumstances under which a reviewing court may vacate the award. The award was procured by corruption, fraud, or other undue means. Or B, there was an evident partiality by an arbitrator appointed as a neutral. C, the arbitrator exceeded his or her powers. Or D, the arbitrator basically refused to hear evidence material of the controversy or.
Yeah, so thank you, Your Honor. I appreciate that. I think it's part C, and that errors of law fall under that, as Washington v. Washington, which was my case, held. Um, and so, an error of law must be apparent on the face of the record, and it must also be obviously outcome determinative in some way. So opposing counsel said that there was never a claim for breach of contract, but that's clearly not correct. If you just look at the arbitrator's own decision, why is the arbitrator addressing this email, this October 16, 2015 email, and saying it's not a contract? Only because there's a contract claim. I mean, otherwise there would be no reason to address that. So it's clear we're claiming a contract, and whether it's a contract in a written form, evidenced by the email, or of which the email is only some evidence, and performance is admitted, although the extent of the performance is disputed. Still that's a contract claim. Opposing counsel notes that there's. I'm sorry.
Let me ask you one question then. Your suggestion is that once we would have to first conclude that under subsection C, the arbitrator's misstatement of law was outcome determinative, and then we get to review that decision of the arbitrator de novo when it's a mixed question of fact and law, or are we held to the factual findings of the arbitrator and then only review the de novo part, or review the law piece of it de novo?
Well, so I cited the Johnson versus Harnischweger Corporation case for the proposition that a mixed question of fact and law is treated as a question of law, because when you make a finding of fact based on your understanding of how the law applies to whatever the factual dispute is, that involves the application of law, and that's always reviewed de novo, whether by the trial court or an appellate court. And I'll note, of course, that the arbitration agreement in this case specifically obligated the arbitrator to follow Michigan law. It said he would apply Michigan law. The arbitrator will follow Michigan law. So, that's what we're doing. And the case law, Washington v. Washington, published case, says, and the court rule as well says, when you're reviewing arbitration, you can review errors of law that are apparent on the face of the record. Yeah, the issue here seems mainly to be one of premarital interest, because opposing counsel says the marital interest was compensated. He finds that strange, but the arbitrator apparently agreed that my client contributed to the creation, existence, preservation, maintenance of this marital asset, so my client got credit not for half the value of the enterprise, but half the increase in value during the marriage. Although our issue too was that the arbitrator made an error of law in that regard too, of choosing the wrong dates for calculating that, and also ignoring the holder's interest or the ongoing concern value, and subtracting goodwill from the value of an enterprise that's not being sold by the person operating it. Goodwill remains part of it if she's allowed to carry that forward. So we think that was also wrong. So my client got credit, got 50% of the difference in value from when the marriage began until when the marriage, well, actually before the marriage ended, but when the arbitrator made their decision. So those are the points I had on rebuttal. I'll be happy to answer any further questions.
Anything?
I thank
We're all
you
set.
for your.
Thank you, Mr. Paul.
Yes, thank you, Your Honor. I would note only that at the beginning of the session, you indicated that your two colleagues were shy.
Yes.
I haven't noticed that, and I'm glad, because I got very nervous that it was a different Stephen Barella that was going to be, hearing my case today. And the real and the one I expected did show up. So thank you
That's
all for
great.
your time.
Make sure you tell your client how sorry we are we dragged this case out, will you?
I will do so, Your Honor. Thank you.
Thanks.
All right, this case will be submitted and we'll be taking a break right now before we pick up the 11 o'clock docket. Thank you for your patience. Okay, so we're back on the record and now calling case number 10, docket number 371471, and that's Bellinger versus Darren Inc.
Ready, Your Honors, Attorney Jim Razor, along with Attorney Amanda Washburn, and we're just fired up to be here. And that was a really interesting group of arguments that you had this morning. And I appreciated listening to the court's wisdom in terms of what was going on. This is the creepiest gas station case on planet Earth with a horrible happenstance. And to me,
But not a foreseeable happenstance, so
well, it's a matter of opinion. Let me tell you my point of view on that.
I think my opinion might matter a little bit.
Your opinion matters a heck of a lot. Let me try to persuade you, Judge. Here's the thing. Here's what I think is important. Here's what I think we're doing here. On the 24th of December, Jamie Peterson goes in and she tells the person in charge of this store, the only person that is in the store, working at the store, there's no QR code to call management. There's no number. If you have problems, call management. There's a person who is entrusted by this corporation to be in charge of the store and to interact with the public. And she tells him that a person who worked there was a predator towards her as a woman, that this person sexually accosted her and offered money to see her breasts.
Does Michigan law require certain factor to be met for someone, you called them in charge of the store? There's a difference between being a store clerk who works behind a desk and might not have any other supervision and somebody who's a manager. Is there any indicia that, I think it was Frank, who you're referencing, had the ability to hire, fire, discipline, do scheduling, any of those things?
It's a multi-part question and it's a good question and it cuts right to the issue. No, he didn't. There's no indication that he was hiring or firing anybody.
So how can his conduct or his knowledge be attributable then to the owner of the gas
Because
station?
it doesn't matter whether he's hiring or firing. He's a notice person. His job is to interact with the public.
And what's your source of law for that?
Upjohn, the Gordon, the Selway case, all stand for the proposition that you have to look at officers and agents who are authorized and charged with the doing of a particular thing. So what particular thing was Schomburg authorized to do?
But don't you, let me pause you. The first part is officer and agent. And there's specific tests to meet officer or agent, right?
Well, the agent portion of that.
So you're saying Frank's an agent.
He's obviously an agent, right? He's taking money, he's interacting with the public.
Well, I don't know if by law he's an agent, maybe colloquially he's an agent.
Well, the case law is what particular thing is he doing? For example, I just had a conversation with Ms. Washburn. If you were in a Walmart and you talked to the greeter about the cashier accosting you, would that be sufficient notice? Well, no, first of all, because the greeter, obviously is going to tell you to get your blank and get out, right? Second of all, no, nobody saw Jeff Dunham. Second of all, there are managers and other people who are higher in authority level than the greeter to Walmart at a Walmart that you can talk to, unlike this little gas station where there is one person. So the question is, what particular thing is he authorized by the corporation to do? And the particular thing he's authorized to do is interact with customers, operate the store, communicate issues to ownership. Ownership said, and Frank didn't disparage the fact that he had a direct link to ownership via text message. Ownership said they also had a direct link to the store via video, but then the defendant says,
Okay,
well,
so
there's
let's
no audio.
assume we take your kind of theory is true, that he had a duty. How long between that complaint and the incident?
3 days.
Okay, 3 days. So you're saying that that's requiring in other contexts, in terms of a company taking prompt remedial action to sexual harassment under the Elliott Larson Civil Rights Act. I mean, there's cases where on the circumstances, 2-3 days of taking, or longer than 2 or 3 days. I mean, it's 2-3 weeks is prompt remedial action is sufficient under the law. You're holding a standard of almost immediate notice and immediate action?
Judge, what a great question. And thank you for that, because that's a question of fact for the jury. That is a classic question of fact for the jury. Was the response to the notice appropriate? That's a classic question of fact for a jury. And the defendant should be free to argue to a jury in St. Clair, like, hey, we didn't have time to react. And then all the factors would go into that. Like, was it a committee in Texas, or was it one person in Bloomfield Hills that was looking at a text message? So that's a great, great thing. And all of these things are great questions of fact. The agency of Frank Schomburg, whether he communicated this, what Jamie Peterson told him. These are all great questions of fact for a jury to decide, because constructive.
Well, whether Frank communicated it isn't a question of fact. There's a deposition that says he did not.
Well, there's a deposition that says he doesn't remember being told by Jamie Peterson those facts. He didn't deny it. He said, I don't remember being told.
That's him. But then the owner of Darren says, yeah, I never got this. I was never alerted of this.
Well, the jury could either believe her or not believe her, or the jury could say that once you tell an agent, once you tell somebody who's in charge of a place of business something, the corporation knows it.
But I still struggle with, you keep just imposing that he's an agent. I still struggle whether under Michigan law, he meets the standards as an agent.
I think, Judge, but of course, as Judge Young pointed out, what you think is more important, right? I think that anybody left in charge of a business as the sole person there, without a way for the customer to talk to anybody else, is an agent of the business. And I think Michigan law absolutely in object.
But there are a number of other ways. What you're presupposing here is that the only way I can gather information is to walk in the store and get it. We all have a computer that we usually carry around in our hand. That would be another way to get it. But what I want to know, and I think what Judge Trebilcock is trying to get you to answer is, what were the indicia of agency that this individual presented to your client?
Well, I believe, Judge, that the indicia of agency was he was interacting with customers, operating the store, communicating with ownership. She wouldn't have known that.
So does a Walmart greeter, to use your example.
Right. That's their job.
Yeah.
Well, a Walmart greeter would have somebody, and that's a good line. So let's go down that line. You tell a Walmart greeter that the cashier has just groped you. What does the Walmart greeter do? They go get a manager. They get on the walkie-talkie. They call a manager. They call somebody with authority to deal with the situation. I'm not saying that Frank Schomburg on his own had authority to deal with the situation. It's pretty clear that he didn't. He had a duty to notify whomever had authority to deal with the situation. That's the breakdown.
But let's suppose that he breached his duty. All right. And we'll take the facts as you state them for purposes of this, obviously for purposes of an SD. So the question then becomes, how does that show notice to the employer?
Well, the question I think then would become, pursuant to Hirsch and Brown and Hamed and Mueller, whether that was constructive notice to the employer, which is a classic question of fact for a jury. That's a classic question of fact. Did that notice to him, was it communicated, or did he blow it and not communicate it? Was he properly trained to communicate it? What were the procedures to communicate?
So your contention is he's an agent because he was interacting with clients, right? Let's stay focused on one thing at a time. Was there anything, or with customers, excuse me, not clients? What else? What other indicia of agency did he display?
He's in charge of the money. He's in charge of the stock. He's in charge of emergency situations.
When
I
you
mean-
say he's in charge, it's because he's the only person in the store, right?
Right.
Okay.
Hey-
So that means he's in charge of a lot of things, but I don't know how that makes him an agent necessarily.
Well, he's not a stranger, Judge. I mean, you're leaving a person in a store who you're paying, who the master is paying, and the master is paying this person to deal with the public in a place with flammable materials and hundreds of thousands of dollars of stock, including alcohol, which is licensed by the state of Michigan for this location to sell. How the defendant is able to get away with a thought that this person is a brainless person who has
So the teenagers, you live in Royal Oak, you've been to Jim's ice cream shop once or twice, I think. No relation, right?
I wish.
Yeah.
I wish they do a
So
great
those, you're
business.
telling me those, or Ray's ice cream, either one,
Yeah.
right? You're telling me those 18-year-old or 16-year-old, one or two of them, they're all-time agents, or let's say it's the end of the shift. They're there closing up and there's one person there. They're agents of the owners of Jim because they're the only ones there.
Absolutely. Those are the people you're holding out to the public. Now, whether it's reasonable that you give them notice versus, looking up on your telephone like just Judge Borello says.
Yeah, don't give me a pay decrease by making me a justice.
I caught myself. That's a question of fact. I mean, I'll give you an example from my own world. If somebody walked into Hotel Royal Oak or Razor Law, which are both small businesses with a local owner, and said that this happened to them, I would know about it in 3.5 seconds, and it wouldn't matter who you talk to. It wouldn't matter who you talk to. And just by saying, well, Frank isn't in a position of authority at all, I think that's a question of fact. I mean, Frank had worked there for quite some time. Frank was well known to the owner. Frank had the owner's cell phone in his phone. I mean,
So your night clerk at Hotel Royal Oak hears that the other night clerk is harassing your customers. That night clerk tells one of your housekeepers. Housekeeper doesn't tell you, you're now liable for that. You
don't,
can be sued for that harassment.
I think, well,
They interact with customers. They're
They
in
do
charge of
interact with
cleaning your
customers.
room. They're entrusted with keys to the entire hotel. They can go in and out of rooms, steal things. They can do a lot of stuff. You're now liable. That's the standard you're asking us to adopt.
well, the standard I'm asking you to adopt is allowing the jury to make that decision, Judge, as to whether there's liability, or did we train our front desk people appropriately?
But I don't
Is
even
there-
understand how there's a question of fact. Frank's deposition says, I can't recall. If Peterson said this to me, I can't recall reporting it to Julie. Julie says, he never told me this. And so where is the question of fact?
Well, there's a question of fact, obviously, as to whether Jamie Peterson told him these facts, right? And what she reported to him. So then there's a question of fact as to what he did with that information. Did he call the son?
It's
Did he call?
it's the latter that there's no question of fact in. He doesn't know if he reported it to Julie. He can't remember. Julie says, oh, I'll help you remember. You didn't.
Okay.
So where's the question of
The
fact?
question of fact is then, did the organization properly train the person interacting with customers to report this incident in a proper way? And Judge Treblecock, let me go back to what you said. There is a protocol at the hotel, like many other businesses, exactly what happens if a guest reports something. There's forms to be filled out and there's things to do that you have to do. Businesses do that because it's appropriate. It protects the public. And it also gives you plausible deniability that you didn't screw up. Let's say that Frank had a form to fill out and Frank didn't fill out the form. That's evidence that the business took precautions and had a reporting protocol. These are all questions for a jury. Was the business careful? I mean, if you look at a gas station selling liquor, there's a lot of bad things that can happen to people. So I'm sure that Frank had some sort of training on what he was supposed to do. And I don't think that a jury is going to buy the statement from the owner of the place that she didn't know. I don't think a jury is going to buy that based on the totality of her testimony, much of which was unbelievable, Judge Young, that she's going to buy that. or that a jury would buy what she had to say. But the whole issue is that there's all these inferences that can go either way in this case, and we should have had a jury to sort out the elements of constructive notice.
So let's
in the
say
case.
even if we buy that, you're saying that you're asking us to believe that one incident that even if we knew about it is sufficient to say that it was reasonable that we'd anticipate this would happen.
Thank you for bringing that up, and let's go into that analysis. And I think the case law is very big. Mueller's on predictability, and Hamed is on similar conduct. So is this predictable and similar conduct, i.e., to Judge Young's question, is this foreseeable? And the answer is yes, and I'll tell you why. Because the complaint was he was accosting women. He was victimizing women. He was being a predator towards women. And the conduct which happened 3 days later was exactly that same conduct of being a predator on women. Now, if his conduct 3 days earlier would have been trying to sell lottery tickets for less than face value, then I'd agree with you. That doesn't have anything to do with it. It's not foreseeable. If his conduct was trying to sell drugs, trying to sell joints at the pump, that's different. But all the conduct is aimed at being a sexual predator towards women. So yeah, I think that a jury could well find, I think a reasonable juror could find, Judge, that that is predictable and similar.
For one incident.
Yeah, absolutely. For one, okay, it depends on the magnitude of the incident, but I can tell you, owning multiple businesses, if somebody that works for me is offering a female customer money to show their breasts, like that's kind of a big deal. Like that's kind of a big deal that you're going to do something about immediately. It would boggle the mind that any reasonable jury would say, oh yeah, management didn't have a responsibility to do that after somebody in a position of power and authority in a business is offering a woman money to see her breasts. And then that leads to him further accosting women. And don't even think about the fact that the woman who owns the place says she has a camera system. She can see what's happening. And forget for a second that she says, I don't do any background check. And had I known what this guy's prior record was like, assaultive behavior, drunk behavior, that she never would have hired him and put him in that position, and that she failed to do any of that in a person that sees literally thousands and thousands and thousands of members of the public on a daily basis. Forget about that whole fact. There was constructive notice to that corporation at the time that Jamie Peterson complained. And then the same conduct occurred 3 days later. And yeah, absolutely. I don't see that this is a hard sell to a jury, but it should still go to a jury. Judge Young, I would love to answer your questions because I want to persuade you based on your earlier comments that you don't like this particular portion of the case. I'm glad I honed in on this portion of the case. What questions can I answer for you? How can I persuade you that this should go to a jury?
Oh, I mean, I think Judge Trebilcock got at my concerns. I don't think there was notice, and I'm not convinced that Frank was an agent, but you've sufficiently addressed both of those.
Then let me keep some time for rebuttal.
Okay, that sounds great.
Thank you.
Good morning, Your Honors. May it please the court. My name is Simone Capadia, and I represent defendant appellee Darren Inc. I'd like to start off this morning by addressing some of the arguments that plaintiff's counsel made this morning. So regarding the issue of constructive notice. So first, I would like to point out the argument that we made in our brief, and I would like to reiterate this morning, is that there is not constructive notice imputed to Darren Inc. So even if accepting plaintiff's argument is true that on December 24th, as she walked into the store and Mr. Harnden offered her money to see her breasts, and then she relayed that information to Mr. Schomburg on December 26th. And then on December 27th, the incident at issue occurred where Mr. Harnden committed acts of sexual misconduct. Taking that into account, first of all, telling one individual does not impute that information to the employer. And that's under Upjohn, where it talks about that information from several employees can be imputed to a employer. So, and to Judge Young's point, Mr. Schomburg does not recall having this conversation with Ms. Peterson, and Ms. Namey unequivocally says that she did not know about this alleged December 24th incident. That being said, so there is not constructive notice on behalf of the point of Darren Inc. That being said, even if there was constructive notice that this December 24th incident happened before the December 27th incident, words under Brown versus Brown, words alone without a particularized threat imminent to an imminent victim is not enough to impute liability to an employer. On December 24th, Mr. Harnden allegedly had words of inappropriate lewd comments to Ms. Peterson. And then on December 27th, he had actual acts of sexual misconduct. That does not make it, the lewd comments does not make the eventual acts of sexual misconduct foreseeable. So regardless of the constructive notice issue, the actual instance that is being alleged would not have put the employer on notice at all. So
let me just say it back to you. What you're arguing is, let's assume that Frank is what I remember his name, was actually told. He doesn't remember the conversation, but let's assume he was. Even that is insufficient to put constructive notice as a matter of law.
yes, that is correct. That is the argument. And then even if there was constructive notice, the constructive notice of the December 24th incident does not equate to foreseeability of the December 27th incident. And then the other arguments, the other points that I would like to make is regarding the fact that Ms. Namey, under TIAS, there is no duty to conduct a background check. And even if there was a background check in this particular case, again, Mr. Harnden's background, a criminal history, it was a 2007 assault and battery, a conviction. It was a 2016 OWI and driving my license suspended. Those, again, do not make it foreseeable that Mr. Harnden several years later would conduct an act of sexual misconduct. And that comes from Hamed, where it talks about the similarity of the criminal background, as well as there's a temporal connection as well too. The driving while the OWI was in 2016, this happened in 2020.
And the EOC would say that kind of violates the ban of check the box policies.
I'm sorry, Judge, I didn't catch it.
I just said that it would also violate the EOC's ban. You can't just check the ban check the box, any criminal background. It's got to be connected to the duties.
Exactly. And there's also public policy rationale. Just because somebody has a criminal history should not preclude them from being able to get a job if they've, moved on from that criminal conviction. The other point that I would like to make is regarding, this didn't come up in the original plaintiff's counsel argument, but I'd like to bring it up because I think it's something that they talk about in their briefs, is this idea that regarding the Trooper McClure's alleged sister or sister-in-law, that information the trial court correctly found was not enough to oppose a motion for summary disposition. And the rationale for that is that it's Ms. Ballinger and Ms. Peterson hearing from Trooper McClure about some unknown person regarding some information that they may have had, some interaction that they may have had with Mr. Harnden. It's all the specifics of that are.
I don't think we.
Okay, sure.
I would move on.
Okay, that's fine. That's fine. And then the last point that I would like to make this morning is that the loss of consortium claims are derivative and they fail for that reason. So unless the court has any questions.
Why isn't this a question of fact, as brother counsel is alleging? First of all, as to agency, do you believe that this individual, Frank, I guess is his name, it was an agent of your client or not? And if not, why not?
Well, I don't think that. So I think the question that I have. So my rationale for that is that even if he is an agent, that knowledge is not imputed to the company, and that's because under Upjohn it talks about needing several employees. This is one instance that allegedly was told to one person. That does not impute to Darren Inc. That being said, I think the constructive notice aspect of it is a little bit of a red herring because it doesn't really matter. What allegedly happened on December 24th does not make what happened on December 27th foreseeable. And that comes from Brown versus Brown.
Again, I don't know that it's a big stretch if somebody's asking somebody to bear their body to them and then they bear their body to somebody else. You kind of lost me there, but why isn't that a question for a jury to determine?
So again, Judge, I would say that under Brown versus Brown, the lewd comments that the assailant and Brown made were very lewd, they were very heinous. They went on for a period of months. The court found that even though they were sexual in nature, even though they commented on a person's body, that they did not ultimately mean that that assailant would later on commit an act of rape. And if the comments in Brown don't rise to that threshold, then the comments here do not.
But to me, the Rubicon there from rape, yeah, okay, maybe. I probably would have decided it a different way. However, here we've got somebody who says, bear this part of your body, and then they bear their part of the body. I tend to think that's foreseeable.
I think the response to that is that under Brown, it is not foreseeable. Unless the court has any further questions.
Do you have an answer to whether or not Frank Schaumburg's an agent?
I mean, I think in the sense that he was a clerk, he was working there, he represented the business. I could see in that circumstance that he is acting on behalf of the business. So I wouldn't necessarily have an issue with him being an agent, but I don't think that the knowledge of his actually imputes to Darren Inc., regardless of whether or not he's an agent. I think that is it's just because one individual knows something doesn't mean that the corporation knows something. And again, John talks about the fact that it has to be several employees or information regarding, so that's my response to that question.
But isn't that from a policy standpoint incentivizing people not to do their jobs here? What you're saying is, if I'm an employer and somebody comes into my place of business and says that this individual who worked here made this lewd remark, should we now train her? Don't tell me that. I don't want to hear it.
I don't think so. And I think in this particular case, the moment that Ms. Namey learned of what Mr. Harnden did, he was fired immediately. So I don't think that in this circumstance or in the case where, I don't think that's a circumstance here where the moment that Ms. Namey was aware of something that was improper, she fired Mr. Harnden. And up until that point in time, Ms. Namey was under the impression that Mr. Harnden was a good worker.
Anything? Thank you, counsel.
Thank you very much.
I appreciate Sister Counsel's admission that there was an agency here, but I would also indicate that Michigan law strongly indicates that that is a question of fact for jury. Let me quote from Jackson versus Goodman at 69 Mishap 225, a 1976 case, which indicates where there's a disputed question of agency, any testimony, either direct or inferential, tending to establish agency creates a question of fact for a jury to determine. But let me go a little further. The best argument is a corporate knowledge and whether it's imputed from an agent or employee knowing it, and it is. Schaumburg was a corporate agent entrusted with receiving information. I mean, obviously, according to Sister Counsel's admission, he was there, he was in charge of the place, he was the only person. And he testified that he would talk to ownership about operational issues. Therefore, the knowledge acquired by him in the course of those duties is imputed to the corporation pursuant to Gordon, Selway, and Upjohn. Let's start with the corporation's own structure. There's no on-site manager. Naeem was the only management. Employees reported directly to Naomi, the owner. Customers interacted with store clerks, and Peterson reported the misconduct to Schaumburg. That's how they chose to set up their store. They could have had a manager there. They could have had an 800 number. They could have had a QR code. They didn't. The Gordon Selway language is when a person representing a corporation is doing a thing which is in connection with and pertinent to the part of the corporation business which he is employed, authorized, and selected to do, then that which is learned by that person is the knowledge of the corporation. That is the imputed knowledge doctrine. Because corporations are not living, breathing things. They only get knowledge through people. So the fact is that because Schaumburg was doing the things that he was charged with doing, which was being customer facing and interacting with the customers and sending that knowledge to the owner. And because of Gordon Selway language that he was within that role, then the corporation knew what he knew the second he knew it. And that short circuits the whole, well, did he actually tell anybody, what was going on? It doesn't matter. His job was to interact with customers, operate the store, manage the store, communicate with customers, and communicate operational matters to ownership. And the defendant didn't try to say and didn't argue to you that he really wasn't within the scope. I mean, obviously, he's within the scope of his job, judges, when he's talking to the public. That's what a person at a gas station does. Gordon Selway doesn't ask, was he a final decision maker? Could he hire and fire? Gordon Selway asks, was he authorized and charged with doing the particular thing, which is talking to the public? Agency is determined by function and not a title. And then the Upjohn case is great for us because Darren created this ownership structure and Peterson used that structure to report. What's important is not only Gordon Selway versus Spence at 177 Mishap, a 1989 case, but what's important as well is Upjohn versus New Hampshire, which creates this whole imputed knowledge doctrine. Under Upjohn and Gordon Selway, knowledge acquired by an agent while performing duties entrusted to him is imputed to the corporation. So to me, these are all issues of fact. The agency is an issue of fact, and whether or not it was transmitted and what was said are questions of fact. And I would really love to hear Judge Young if you want to ask me any questions about that, because you seem to be doubting, but mind reading is one of the things that Razor Law Firm does not entrust me with because I'm bad at it.
Have any questions?
No.
No questions.
Thank you.
Yep. This case will be submitted.
Thanks, Council.
Now calling case number 11, docket number 373-855. In re the conservatorship of JK.
Good afternoon, Your Honors. I'm Bill Cashin, appearing on behalf of the appellant, Michael Cavo. This is really a bit of a probate, nightmare story for me, because you have a mother who treats her children equally and is helping both of them and giving gifts to both of them over a period of time. When mother gets Alzheimer's, gets dementia, can't remember anymore, that's when the sister, Heather Hayek, becomes mom's conservator, looks in the bank records and say, Mom, you transferred $87,406.53 back in 2017. And well, that's really mom's money somehow. And it's interesting in probate court, and I'll come back to this later in the argument, but the argument's made that statute of limitations or the affirmative defense wasn't pled. Well, there wasn't a complaint filed or an answer. See, this is a probate case. It started off as an accounting issue and morphed into what assets belong to mom. So the court schedules an evidentiary hearing. There was a car, there was a boat, there were some other accounts, there was jewelry.
Well, let's talk about one of the big procedural threshold issues that you've got to overcome is this statute of limitations issue.
But it wasn't raised?
Yeah.
It was raised at trial, correct? And it was argued in the directed verdict. And no argument was made at that time that you can't raise the statute of limitations because you didn't raise it. They didn't argue that. You cannot bring that up for the first time on appeal.
So the fact that you didn't raise it in your first responsive pleading doesn't waive it, but the fact that they didn't say something does waive it. That's your argument?
No, I think it's not, well, you're onto two things. One, there's not a formal complaint and answer filed. That's one of the arguments by the appellee, is that this court has no jurisdiction because there was no complaint and answer. This was a petition. So I don't think the waiver rules should apply to a petition because it's a different format and how the probate court handles it. It's not your formal complaint in 28 days to answer.
Is this the issue about waiver relative to probate court? Is there a published case that states that?
No.
So
I
this
did
would
not find
be us giving what's in tantamount to new law, correct? That's
I
what
don't
you're
think
at.
there's any law applying the waiver of a statute of limitations and affirmative defense in the context of a probate court petition as opposed to a CZ action where you have a formal summons and complaint.
Help me understand, maybe I misunderstood that, but you had a petition, then you filed a response to the petition, right?
I believe at one point a petition was filed objecting to his accounting, asking. to
Okay,
determine
and then there was a response to that filed.
Yes, there was.
Okay. And in that response was statute of limitations raised?
No.
Okay. Why is that not akin to having having a complaint filed, i.e. the petition, and then your response, which is i.e. the answer, and in your answer, you fail to raise statute of limitations of the defense? Why is that not analogous to every other civil proceeding?
Because with the petition, it's not subject to the same rules of pleading as a complaint from our practice. And it's
what court rule can I look at that tells me that, or what published binding case can I see that tells me
other than
that?
the 501, I think it is. It says you can commence an action in probate court by either filing, a petition or by commencing a CZ case. This should have been commenced as a CZ case.
Is your response to the petition, is that a responsive pleading? Does that qualify as a pleading? So doesn't that then get us into the case law that says failure to raise statute of limitations in your first responsive pleading waives it?
If you carte blanche apply that rule to petitions in probate court, yes. But I also think it's incumbent upon the opposing side to raise that defense, and they have to raise it before the Court of Appeals level.
Okay, so that gets back, I think, full circle to what Judge Borrello said.
I mean, that gets ahead of me in my argument, but there's a number of cases, but certainly the Department of Environmental Quality versus Marley, 314 Mishap 306 in 2015, that the court, you can't raise issues for the first time on appeal. And that's what they're doing here. If they argued to Judge Harrison in probate court that you waived it, she could have allowed it as a defense, right? But they never asked her. They waited until we come here to the Court of Appeals, and you can't do that. You have to present that argument to the trial court so the trial court can consider it. I believe the trial court certainly has the authority.
I thought the trial court issued a ruling on the issue of statute of limitations in this case.
She held it was told by concealment.
Okay.
So
So
they
she
addressed
did
it on the
rule on
merits.
it, is my point. You said that this was something new, or that was your suggestion.
The defense to the statute of limitations argument that it wasn't raised as an affirmative defense.
Oh, okay.
That's being raised for the first
Specifically
time on
that,
appeal.
okay.
Oh,
And
but
not-
just a different form, but statute of limitations was raised below, but just a different iteration of it.
It was not raised, the issue of the statute of limitations was not raised in the pleadings. They were filed a year or whatever before, and they had several hearings between that ended up in this one. So it's very loose with all these different moving parts. But my argument is that even assuming it should have been raised and wasn't in the pleading, at the pleading stage, at trial, when the defendant asserts the affirmative, asserts that affirmative defense of the statute of limitations, it's incumbent upon the plaintiff right then and there at the trial court level to object and say, Judge, they can't raise the statute of limitations because they never raised it in their pleadings.
I got to tell you,
Right.
counsel, I'm totally lost.
I'm sorry.
I think,
help me out here.
yeah, my understanding of what you're arguing is that your failure to raise the statute of limitations in your first responsive pleading was not argued to the trial court. They argued statute of limitations on other on other grounds,
essentially,
on the
yes.
merits.
So
But
I
if
don't-
the trial court's ruling was ultimately correct, but for a different reason, certainly this court could affirm, correct?
I don't believe in this situation because if it's a different legal theory that you would reverse the trial court on, but affirm on some different legal theory, that's not the situation. This is something in the discretion of the trial court. The trial court could allow an amendment to the pleadings at trial. The court could allow it. So you can't skip the trial court judge, skip her making that decision and exercising her discretion. And my argument is she did exercise that discretion because she didn't deny the defense on the grounds that it was waived. She denied it on the grounds on the merits under her interpretation that it was told because it wasn't discovered until 24.
I understand that. So that I'm just trying to understand your argument. So then your argument is that's all that's before this court. They can't now on appeal raise another issue. Is that regarding the statute of limitations?
Yeah, I think it's a new issue that was not presented to the trial court.
I got it.
It has to be, especially when it's an item that involves the trial court's discretion.
All right,
She
so
didn't
then
have the
next,
opportunity.
gotcha. I think we understand that. Now, next, go to me, help me understand why you think it's clear air and how we can disturb. You had two competing versions of events. You had sister saying, no, you transferred this wrongfully from mom's account to yourself. You had brother saying, no, I had permission. There's some issues with the deposit slip listing the girlfriend's address, whether the signature is actually his, all that kind of stuff. Judge heard all this, made a credibility determination and said, nope, I believe sister, not brother. How can we touch that credibility determination?
Well, two things. One, it's not disputed, and they argue it in their brief, and everybody's argued, that this money came out of an account that was in Gene Kawa's name, right? This was in 2017. That's also undisputed. In 2017, the petitioner, Heather Hike, the sister, testified at trial that mom knew what she was doing. Mom could make her own decisions. Mom could make her own medical decisions. Mom didn't need a guardian, didn't need a conservator. So in 2017, Michael Kawa could not transfer this money. It was under Gene Kawa's name alone. She withdrew it. Her name is on the bank statement. And they transferred this into another account. So as I was preparing for this argument and looking at the associate that tried this, I'm thinking, where is there any question of concealment? Gene Kawa transferred the money.
But
There's no
wasn't there
concealment.
admission by the brother that it was in his handwriting, the deposit slip?
And there was arguments on whose initials are on the deposit slip, where the money was deposited. And we admit it was deposited into his sole name. What I'm saying is that the mother did the transaction. He couldn't access her account. He wasn't power of attorney. He wasn't joined on the account. Mother did this. And you can't wait 7 years for mom to get dementia and can't remember what she did. She couldn't testify at trial. She doesn't remember. And that's when sister comes in after the fact.
Maybe should have raised that in your first response of pleading.
Your Honor, I think that goes both ways. And they have to assert that if they're going to rely on that so that we would have had an opportunity to argue that. We're arguing in front of Judge Harrison. We argue that thing. They didn't argue that you didn't raise it. They didn't argue it was waived. They argued it was told because of concealment. On appeal, they're arguing it's cold because we think somehow, because the attorney argued it, there's a fiduciary relationship back then that gets rid of the requirement to have an affirmative act of concealment. But I'm cutting through all that saying, wait a minute, Gene Kawa is the one that transferred the money. And Heather Hayek and Michael Kawa both testified she knew what she was doing in 2017.
But you had, I guess where I struggle with, let's say I listen to you and I'll listen to brother counsel and I find your version more credible, right? The court below disagrees with you.
No, they don't. The court below does not disagree that this money came out of an account just in Gene Kawa's name. That's not disputed. They just missed the significance of it. It's not disputed that the money came out of an account in her name alone. That's what happened here. That's the facts. They were arguing in probate court, we still think it's mom's money somehow. And if it was still mom's money, that's when you run into the statute of limitations. Then why didn't they bring this earlier? Heather Hyde, mom lived next to Michael. Talked to Heather all the time. It wasn't isolation or anything. They were together and knew all of this. Why was no action taken? Why did mom take no action? And I'll just finish because I'll see you. I'll give you more. But with the statute of limitations, it's to protect the defendant from stale claims. When you lose testimony and you lose evidence. We couldn't get bank records 7 years ago. More importantly, we lost the testimony of Gene Kawa, who made the transaction. And if she made the transaction where she was competent, how can you undo it 7 years later without any direct evidence that there was some type of fraud or something, she was coerced? And even if she was, why did she not take action? The sister argues, well, I didn't see it until 2024. Yeah, she didn't see it. And that's when she brought the claim. But mother made this transaction in 2017 when everybody admits she was competent. And the only way to make it, to get money out of an account under her name, the only way the bank would allow it is for her to go in and sign and voluntarily transfer that money. So that's why we have the statute of limitations, to avoid the defendant being deprived of evidence that would vindicate their cause. So that's where I urge the panel to reverse this.
Thank you.
Thank you.
Good afternoon, Your Honors. May it please the court, Paul Zaleski on behalf of the appellee in this matter. Your Honors, unfortunately for appellant, Michigan court rules defeats his argument. And under MCR 5.001B, relation to probate court proceedings, it states, and I'm quoting, references to pleadings in the Michigan court rules also applies to petitions, objections, and claims in probate court proceedings. And of course, the definition of responsive pleadings in MCR 2.110 defines that as complaints, counter complaints, cross complaints. So these two court rules read in harmony means that a petition is the equivalent of a complaint.
So how about his argument, and I think Judge Barella touched on this a little bit. He's trying to say, well, too bad you didn't argue this clearly enough or in this fashion down below, so we can't consider it. How do you respond to that?
I think this is a classic example of why affirmative offenses must be pled in a first responsive pleading to afford the adverse party to maintain a responsive position rather than at the closing of proofs at trial for the very first time saying, oh, well, Your Honor, the statute of limitations applies here, so he can't bring their claims. It doesn't afford the adverse party time to properly respond to that. So in essence, counsel responded the best they could because the context of the court's discussion in response to the motion for directed verdict and this being raised for the first time was, well, wait a minute, isn't it when the claims discovered? And then there was some discussion of whether there was active concealment. The fraudulent concealment statute was never mentioned. I guess it was discussed by reference, but not by implication. So the appellant's attorney didn't even bring up that statute specifically by name. It was just kind of talked to and spoken about generally. And as Judge Barella definitely adequately pointed out, and this court has long held, and I'm just quoting from Bailey versus Atrium County, although there's many other cases, we will not reverse a trial court's decision when it reaches the right result, even if it was for the wrong reason. And this court's consistently maintained that position. And it's especially applicable in a situation like this, where you have a party that had an affirmative legal duty to raise this defense once that petition was received. And now, mind you, this defense wasn't only failed to be addressed in response to the petition itself, but the trial court before the evidentiary hearing or trial, if you will, ordered trial briefs be filed. The appellant didn't even file a trial brief. Appellee did, along with witness list and other things, but the appellant didn't even file a trial brief, so it could have.
I'll see if I have any gold stars I can give you for that. I am going to interrupt you. I just want to get one thing out of the way real quickly.
Thank you.
And I think I know the answer, but I want to make sure I'm correct. You don't dispute that the trial court's ruling relative to the relative to the issue of the statute of limitations was erroneous.
I don't believe the ruling itself was erroneous. I believe there was sufficient evidence presented at trial of active concealment, and the court cited to it itself, but here's a deposit slip that was made out from an account only in the decedent's name.
I wasn't real clear.
I'm sorry. Your Honor.
What I mean, no, it's totally my fault. It really is. And just ask my wife and she'll affirm that no matter what the
Don't speak to
discussion.
mine.
My question is, the court made a ruling on the applicability of the statute here.
Yes.
Just the only issue I have right now that I want to ask you is, was that ruling correct specifically as it related to the application of the statute of limitations?
I believe it was correct.
Okay.
In relation to the general discussion of the fraudulent concealment statute that was never mentioned by name. I think that if it was properly pled, it could have been raised in a different way, because the most easy, it could have been met with a dispositive motion, Your Honor, prior to trial, that the appellant hasn't even raised the statute of limitations as an affirmative defense. They're prohibited from arguing it now at trial.
I take it you practice in front of this court a lot because you're being very diplomatic, but I understand the point and I appreciate it.
I try to be well prepared, especially for this panel, Your Honor. So I took extra time to prepare a brief board, almost like I was in moot court again. But Judge, outside of the statute of limitations defense, the court certainly has recognized that we do not disturb findings of the probate court's ruling on factual issues except for clear error. And in re conservatorship of Brody, which I cited in my brief, it states the reviewing court will defer to the probate court on matters of credibility and will give broad deference to findings made by the probate court because its unique vantage point regarding witnesses, their testimony, and other influencing factors not readily available to the reviewing court.
And here the trial court, and again, correct me if I'm not wrong, as you know, and I appreciate your patience in having to sit through all these other cases. So they get jumbled in my little mind, but the trial court didn't seem to think that the appellant was highly credible here.
No, and there was a long history of that gave rise to it. There are previous petitions and in issuing its oral opinion from the bench, the probate court even mentioned, the appellant at one point locked his own mother out of the house and a show cause had to be brought against him to take these locks off. But the court also considered evidence that this deposit slip was in an account that was designated to the mother. And then the deposit slip does, even though the appellant's claiming it's a loan, it doesn't have appellant's name on it, it has the mother's name. And then conflicting testimony was given by the appellant under exam and cross-exam, where he finally admitted, yeah, all that handwriting, including the initials, was really mine. So the court took issue with that in its verbal opinion from the bench. This was an account that was opened by the appellant in his own name in 2015 that it was deposited into. He added his mom's name on later under the stated reason that, well, this was for estate planning purposes. So you have a decedent who can't testify, but you have money being taken out of one account into her name with the deposit slip that's purportedly going into account with her name on it. And contrary to what brother counsel argued, the testimony at trial from the appellant herself in this case, being the decedent's daughter, was that in 2016, her mental facilities began to fail, and describes an incident in 2017 where mom got lost driving from Target, a store she's been going to for over 30 years, and didn't know where she was, called her on the phone, panicked, and had to be led home. And then you have a best friend for over 18 years that testified at trial, this Debbie Habersky, that in 2018 or 19, They met at Eagles Club and she was frazzled and unkempt and didn't recognize people she's known her whole life. So we have diminished capacity evidence introduced to the trial court to support the trial court's ultimate conclusion as the finder of fact that there was concealment here and these funds were wrongfully converted from the estate.
And there was, I think in this case, a lot of testimony from your client regarding how that they had always discussed these matters in an open way and the explanation as to why your client was given money at one particular time for the cottage and all of that. And there was none of that relative to this particular withdrawal.
That is 100% correct. There was abundant testimony of that by the appellant that anything of this nature most certainly would have been discussed as a family unit. No one's going to just close out and wipe out over $87,000 in account and give it to someone without her own brother.
And wasn't, and again, I'm trying to refresh my memory, so forgive me for asking what might be silly questions, but wasn't appellant's basic argument that mom gave me this money to make up for the money he gave to my sister for the cottage, but then the evidence showed that the cottage was, for lack of a better term, a joint family venture that everybody shared in.
Absolutely. And there was testimony that it was basically a family cottage that was being used every weekend by everyone jointly. And that this was common knowledge that the mother was giving the money for the purchase of this cottage.
And all right, that goes back to my prior question of this was something that was openly discussed at the time between all of the parties. Okay,
Yes,
thank
and all
you.
these facts were made available to the probate court as the trier of fact in this case.
And certainly we can't touch them or just unless they're so outrageous that they, fall outside the scope of reality is really how I look at it.
That is absolutely correct, Your Honor. And, Your Honor, the elements of conversion here were found by the trial court to be met. And notably, the appellant didn't seek treble damages, statutory conversion. It was apparently pled as a common law claim of conversion of exercising wrongful demeanor or control. But even if it were a statutory conversion claim that requires a party to show that the asset or money converted was of a particular use for the appellant, he testified he used it to purchase commercial property for himself. So frankly, if I were arguing it, I would have asked for treble damages at that point in time. But, we're left with the trial court's judgment. And unless the court has any further questions of me, we would ask this honorable court to affirm the ruling of the lower court and the decision of the probate court to grant judgment against the defendant in the amount of $87,000, $406.53.
Real quickly, you don't dispute if we were to issue a decision stating that he's waived any statutory claim, he's going just simply under a common law claim. That's your understanding as well?
It's not stated on the record one way or another. The elements are essentially identical, except statutory conversion, of course, under this court's various rulings requires the proving of it being used for a particular purpose. I think it meets both.
Okay.
And you'd agree, though, I didn't see any argument on that issue from appellant.
No, there's none.
Thank you.
Thank you, yours.
I was pulling up the transcript. I'm not playing on my phone. Because I think it's important.
It's more fun to play on the phone.
Yeah, I wish I was, Your Honor, but I'm not. Because they brought up this issue where she got lost. Heather Hayek was asked specifically about that. And what she said was she followed her mother home. Right? And then she was asked, well, did you come to court and say mom needs a guardian? Because she was so out of it in 17 and got lost. And Heather testified, no, she didn't need a guardian at that time. And Michael lived right next door and we were always talking. So you didn't think she needed a guardian. You thought she could handle her own medical decisions at that point. She could, yes, she could, yes, she could. And she didn't need a conservator. So that's the testimony, uncontradicted. Also uncontradicted that it came out of an account that mom had to take the money out. So to say that you can assert, a failure to assert, like they say, we didn't have time to respond because this was first raised, the statute of limitations, in your closing argument. You had time to respond. that we don't have time because we're prejudiced because it wasn't raised.
You don't dispute his citation to the court rules, though, correct?
No, Your Honor, I believe that the petitions in probate court get handled very informally. Does that change those court rules? No. Does it put more emphasis on the probate judge's discretion who handled the case on whether it's appropriate to allow that defense to be asserted at trial, even though it wasn't raised?
Are you telling us that a trial court has discretion to ignore court rules?
I think the trial court has discretion to allow the amendment of pleadings to raise the affirmative defense. The trial court has the discretion to conform pleadings to the evidence that presented at trial. So they do have the discretion, but it's not ignoring the court rules, no.
What discretion would a trial court have regarding the rule about having to plead the statute of limitations in your first response of pleading? I don't see any room for discretion.
They can allow the pleadings to be amendment to retroactively raise the affirmative
Oh,
defense, right? They can do that. That's within the trial court's discretion.
But
That's
that
why
wouldn't
it's
be
so
raised
important.
in the first, that
Well-
wouldn't be raised. So in essence, you are saying that the trial court has the power to, in essence, rewrite some certain court rules.
No, the court rules give the trial court the authority to amend the pleadings. So if you amend the pleadings to bring them into compliance with the other rule, the trial court isn't changing the court rules, the trial court's following them. But that's the point of my argument. They didn't give the trial court the option of allowing an amendment to the pleadings to allow this.
Did
It's
you
almost
ask
like
for an
it happened.
amendment?
It happened de facto.
Let
Your
me,
Honor.
did you ask for an amendment in this case? So that you could file a defense of statute of limitations?
No, it was verbally asserted at trial and it was not objected to on the grounds that it wasn't raised. And it went on to argue on the merits and the court made a determination on the merits of that defense. And it's not the case where, well, they're right for the wrong reason because we don't know what what discretion the trial court would have exercised. They may have allowed us to amend our pleadings. That's why we have the rules that you can't raise an issue for the first time on appeal that you never presented to the trial court. That's also why we have statute of limitations. How is there conversion when mother took the money out herself and put it in the deposit slip to her son at a time when everyone admits and agrees she was competent? And that's where the trial court committed reversible error because they're more focused on whose money we think this should be instead of at what actually happened. Mother did this when she was competent. That's why.
But that's not what the trial court found. And I think
They didn't.
let me finish,
Sorry.
please. Judge Wilcox's point, well taken, is we can't disturb those findings
What did the trial
unless
court
they're
find?
outside the realm of
Trial court.
common sense.
The trial court didn't find that Michael took this money out with power of attorney or a joint account or robbed the bank. No, the court did not make that determination. That's the underlying fact. That's what makes the court ultimate determination a matter of error because it's not about concealing anything. Mother transferred the money when she was competent. If it was a wrongful transfer at that time, mother knew the transfer happened. She withdrew the money from the bank. She only had 3 years to do something about it, and she didn't. But more importantly, neither did the sister, even though they talked and did all this. So why is sister coming back only after mom's incompetent? That's why you can't let them do this, Your Honors. Thank you.
Thank you. This case will be submitted. Thanks. Now calling item number 12, case docket number 375178. It's PBM Partners LLC versus Dickinson Wright PLLC. Thank you, counselors, for your patience today on what turned out to be a very long case call. So we appreciate you sticking around and turn it over to you for argument.
Well, good afternoon, Your Honor. Your Honors, I will, given that
This is
the
another
date's late.
statute of limitations case.
Yes, it is. We believe that the only statute at issue in our case is MCL 600.5838, Section 2, which is the better known as the discovery statute. And I would further say that I don't believe that we could have filed this legal malpractice case prior to May 29th, 2024, which was the date that Judge Davis out in Delaware made his opinion in order, finding that what I'll call the Frankel letter violated the contractual non-disparagement and confidentiality provisions that Mr. Bloom was bound by with Phoenix, the entity that was
I
suing
think
him.
our Supreme Court might disagree with you. In Gebhardt, they specifically wrote that in cases such as this, it would be up to the plaintiff to commence the action either within 6 months of the alleged malpractice occurring or within 2 years following termination of the attorney, and then to hold that claim in abeyance pending the outcome of the underlying case. You didn't do that here.
Well, I respectfully disagree. I
That's
think
Gebhardt at 551, by the way.
in the Gebhardt case, a woman was convicted of aiding and abetting a rape of a child. Upon her conviction, she then hired a new lawyer to seek a new trial. And she was not only granted, the court went farther than her motion and actually acquitted her. The prosecutor took that up on appeal, and Mrs. Gebhardt waited until the appeal was exhausted before they actually filed a legal malpractice case. And Gebhardt said, you blew 2 years. So the 2-year statute under 5808 or 5805 section 8 is gone. And you also blew the section 5838(2) of 6 months because your malpractice claim had vested. You had a malpractice claim which vested at the time of the conviction. And meaning that there was malpractice, there was an appreciable loss, aka a conviction, and there was proximate cause. And so the clock started ticking upon that conviction. You can't wait until the appeals are exhausted. In this case, I'm saying the same thing, Judge Borello. I'm saying,
Actually, no, respectfully, you're not, because what you said was, and what I was replying to was a completely different remark, which was we could not have brought this case until there was a verdict. And what I'm saying is that's not true. And our Supreme Court in Gebhardt specifically stated you don't have to wait, and then actually went further and said this is the procedure that you should use in similar circumstances.
in Gebhardt, what they were focused was the finality of the judgment, meaning the appellate process.
I mean, I understand you're going to limit Gebhardt, again, solely to the issue of we couldn't have brought this case before that. Our Supreme Court has given you an avenue to do just that. So
Well-
that statement, at least in my mind, isn't correct.
Judge, I don't know how we would, in good faith, file a legal malpractice claim against the defendants prior to Judge Davis's opinion. We did not know if there was malpractice because the malpractice was a predicate event. We were in a trial.
You were put on notice you were put on notice that there was going to be a trial in Delaware, and that the trial was mainly going to be about this letter, right? That I forget the fellow's name, had written, and so you did know.
Oh, we
just didn't know what the amount was.
Yeah, so just to piggyback on that, you knew as soon as you had to retain counsel to defend in response to that letter, you had damages.
No, I disagree, Your Honor, respectfully. We had to defend a case. We had to defend a case that was alleging that the Frankel letter violated the contractual non-disparagement provisions that Mr. Bloom had with Phoenix and the confidentiality provisions that Mr. Bloom had with Phoenix. We had to defend against that case. The attorney fees that were incurred in defending that case. If we would have went out and filed a legal malpractice case, as Judge Borello noted, on say the next day that we were sued by Phoenix on May 12th, that would have become Exhibit A in the Phoenix case as an admission that the Frankel letter disparaged and that the Frankel letter violated violated the confidentiality provisions of the Phoenix case. We defended that case all the way up through trial. And the trial court issued its opinion on May 29th, 2024. So it's the reason we cited the Pete Marwick case, which was a Florida Supreme Court case, which talks about that Hobson's choice, that if you are, in that case, it was an accounting malpractice, but if you are fighting an IRS determination as to a tax liability, and the outcome of that IRS determination then becomes the predicate for filing a accounting malpractice case, that case said that it would be inherently unfair to require the plaintiff to file during the ongoing defense of that claim to file a legal malpractice case. That's which would have to admit that in fact, in this instance, disparagement, contractual disparagement and contractual breach of confidentiality occurred.
But to Judge Borello's point, given the state of binding case law, that seems an argument better suited for the Michigan Supreme Court and asking them for these policy reasons to overturn the case that binds us and says otherwise.
I have read Gephardt, and I don't read it to say that. Gephardt analyzed Mrs. Gephardt's claim under 5838 Section 1, which is an accrual statute, and then did a separate analysis under 5838 Section 2. And under 5838 Section 2, the court found that Mrs. Gephardt knew that she had a possible claim against Mr. O'Rourke when she moved for a new trial. At this time, she was able to allege elements of a malpractice claim. These elements are, and they go ahead and they state the elements. Plaintiff was clearly able to allege the first two elements at the time of her motion for new trial, which would be the existence of an attorney-client relationship and the acts constituting the negligence. The last two elements are generally more problematic to analyze under the discovery rule. One could argue that damages and causation were uncertain until the plaintiff obtained a final judgment of acquittal. However, harm is established not by the finality of damages, but by the occurrence of identifiable and appreciable loss. So what Gephardt was saying in analyzing the discovery savings statute in Mrs. Gephardt's situation is that she, in fact, had all four elements upon her conviction. And what I say is that we did not.
So your argument is that Gebhardt does not have the difficult strategic choice that you were faced with because of the parallels between ineffective assistance or whatever and malpractice. So your argument is if this is more like the Florida case than Gebhardt, because that's where you're faced with the difficult choice where your lawsuit could be used as evidence against you.
Your Honor, I think the Florida case is more of a policy issue of the as I say, the Hobson's choice issue. With Gephardt, I think Gephardt was suggesting in this separate analysis of Section 2 that Mrs. Gephardt had all four elements. And what I'm saying is that we did not have all four elements until May 29th of 2024. We did not have a determination of malpractice as a matter of law. When I say malpractice, I'm talking about a determination that the Frankel letter violated Mr. Bloom's contractual non-disparagement and confidential provisions. We did not have that until.
So you said there are four factors. So you
Yes.
admit at the time of the letter, factors one satisfied, factors two,
Factors one we had,
factor two.
we did not have.
Okay, factor three,
We did not have.
factor four.
We did not have.
So you only had factor one is what you're saying.
Correct. We did not have a predicate determination that the Frankel letter violated and disparaged or violated the contractual disparagement provisions. We did not have.
Are you suggesting that in order to have a claim, you have to have a trial court rule on the issue?
No, Your Honor.
Okay.
I am in this case, though.
Yeah, that's. what I
No, that's
thought.
what I was thinking too. That's why I was trying to figure it
I am in
out.
this case because it's the facts of the case. There was an underlying, the malpractice here occurred as a result of an underlying lawsuit that was in fact went to trial and in fact.
So you're
had an opinion.
actually arguing to us, it wasn't malpractice until a judge said it was malpractice.
Yeah, as a matter of law. The issue before Judge Davis was not whether Mr. Frankel committed malpractice, and I want to make that clear. In answer to your earlier question, the question before Judge Davis was whether the Frankel letter violated contractual
I
restrictive
understand the
covenants.
difference.
And when the judge determined that that in fact happened, that event then is what supports the claim of malpractice. Prior to that event happening, because my clients were on the other side of that trial, they were defendants in that trial. They took it all the way up through trial. They were of the position that the Frankel letter did not violate those restrictive covenants. So it was the finding as a matter of law by Judge Davis that prompted the malpractice. And the losses that flowed as a proximate cause of Judge Davis's opinion are the attorney fees that were incurred. The attorney fees were incurred prior to that time, not because of malpractice, but because Mr. Bloom had been sued.
Explain to me how even you said you don't have factor two, that the acts constituting the negligence that occurred. How can you say that once that letter was mailed, isn't that the act constituting the negligence? So don't you have to concede at least factors one and two were established?
Because we'd have to establish that letter actually violated the non-disparagement clauses of Mr. Bloom's contract with Phoenix. That was the issue. Mr. Frankel, who was the attorney from Dickinson Wright, had in his possession those those restrictive covenants before he wrote the letter. But the issue of whether or not they violated that was something that Mr. Bloom contested throughout a trial that resulted in the opinion in May.
Any additional questions at this
No,
time?
I
No.
understand.
So you have
Thank
you have a little bit of time for rebuttal.
Yeah,
And
thank
we'll
you.
hear from.
Good afternoon. My name is Scott Hamilton for the defendants, FLEs, Frankel and Dickinson Wright. I just want to respond to a few things that Mr. Shea did. And of course, if you have any questions before then, just let me know. Gephardt controls this case. There's no doubt about it. And it controls it for two reasons. Number one, it sets out the touch point at which a cause of action accrues under the 6-month discovery statute. It accrues when a plaintiff can identify an appreciable loss. Those are the terms. And in fact, the plaintiff appellant in this case recognizes that. At page 17 of their response brief in the lower court, they say the following. For legal malpractice claims brought pursuant to the discovery rule found in MCLA 600-58382, as is the case here, the running of the statute of limitations begins when all of the elements of the damage accrue, albeit not by the finality of the damages, but by the occurrence of identifiable and appreciable loss. Close quote. And that is a quote not only from the appellant's brief, it's a quote from Gephardt.
Right.
That's at page 545. That's the.
I think nobody debates what Gebhardt says. I think it's with that particular quote, a question of what does identifiable mean?
Right. Identifiable and appreciable loss. And the thing that appellant just skips over in his entire argument is the fact that the Phoenix action was filed on May 11th of 2021. And on May 15th, 4 days later, we receive a letter from the plaintiffs in this case saying, we're only being sued because of your malpractice. They directly accuse the firm of committing malpractice in writing the letter that gave rise to the Phoenix lawsuit. They identified loss. Now, Mr. Shea says, well, if they filed a malpractice action the next day, they may not have been able to show loss. They didn't have to file it the next day. They had 2 years from that point to file it. And in that 2-year period, they not only accused Dickinson Wright of malpractice on May 15th of 2021, on July 16th of 2021, they sent another correspondence through their counsel demanding the production of our malpractice policy because they knew they had a malpractice claim. And even beyond that, on May 9th of 2022, they sent us the last bit of correspondence. And that was a demand that Dickinson Wright indemnify them, take over the defense of the Delaware action because it was all Mr. Frankel's fault in their mind. And they said in that letter, we have incurred hundreds of thousands of dollars in attorney's fees, and it's all because you wrote this letter and we're now being sued over it. They didn't have to wait until the result of that trial for them to have an appreciable and identifiable loss. I think I can sit down after saying just that, because that in a nutshell is the way this has to be resolved.
Am I correct? Because you could have had, let's say the verdict went the other way and they said, nope, didn't violate the covenant. They could still assert malpractice for just sending a letter.
I would be shocked if they didn't file a lawsuit
Right?
saying we just went through $200,000 worth of legal fees. We won.
Right.
Congratulations for us, but we're out all this money and we're going to look to, and it would be identical. The complaint would be identical. Yeah, I think that's absolutely right, Judge, that would be the identical result, which illustrates the fact they didn't have to wait for the end of the Delaware action. The only other thing that I'll say, and it's only in response to what Mr. Shea said, is with respect to the incongruity in his reliance on Pete Marwick, which I think is the only case that exists for the proposition that it's difficult to assert both kinds of claims simultaneously. That again is taken care of, as you point out, in Gephardt, and it dealt expressly with that issue. The Michigan Supreme Court, and this is in the brief, I'm just quoting from it, but just to illustrate the point, Gephardt held on page 551, in order to put the defense attorney on notice that he will have to defend against a malpractice claim and thereby honor the policies underlying the statute of limitations, the malpractice plaintiff must file his malpractice complaint within 6 months of discovering the existence of the claim or within 2 years of his attorney's last day of service in the matter in which the alleged negligence occurred. With this claim preserved, he can and should seek a stay of the malpractice suit until the other case is resolved.
That's been a brilliant judge who read that to opposing counsel. So my point to him was, there is an avenue and the Supreme Court has told you what it is. So you can't tell me I didn't have an avenue.
Exactly. And, I cite the case, New Products Corporation versus Buxelon. That's just as an example. It's exactly what happened there. We have an ongoing lawsuit. in an underlying matter. Plaintiff accuses their prior counsel of malpractice. They file an action in Wayne County. They stay it the next day, pursue the other case, doesn't go the way they want it. So they reactivate the claim against the law firm. I mean, it's a simple, it's not just a simple procedure, it's a binding procedure. I mean, it's what the Supreme Court has said ought to be done in these kinds of cases.
And even though I make more than they do, a fact which I love to point out, I can't overrule them.
I think that, yeah.
They will always tell me about that part. So we're bound to Judge Young's earlier point. We're bound by Gephardt.
I believe
Gephardt
so.
controls.
I don't think there's any basis to distinguish it. Therefore, Spidey. Unless anyone has any additional questions, I'll take my seat.
Thank you for your patience.
Thank you.
Oh, thank you. Thank you.
Very well.
We have a little
breathed.
time for rebuttal.
Now, does the firm give you, do you get like 2 days off for handling this, or do you get like a Subway big sub or something? I mean, are you going to be adequately compensated? Because I'm worried.
Well, Judge, I get the feeling I should invite you to a management.
So the answer is no, you're not going to get anything.
For the record, my answer is I will be buying raised.
Every time I had to do something on behalf of the firm, that's what my partners told me to. Good job. We already are paying you.
Your Honors, 2 quick points. Number one is that if we did lose the case, we would not have pursued a malpractice case. Because if we had succeeded in the case before Judge Davis would have determined either that the Franco letter did not violate the contractual provisions, or Judge Davis would have determined that the attorney fee shifting provision would have applied and the attorney fees would have been paid by Phoenix. So we would not have pursued a malpractice case.
But you
then.
could have, whether you would have or not is irrelevant. The fact is you could have,
Well,
because you had incurred damages at that point.
we had incurred attorney fees, we had incurred attorney fees, hiring attorneys to defend us in the Phoenix case. That's what the loss was. The Dickinson right, Franco didn't own that until after the judge's opinion came out. That's my argument. The last thing that I'd like to say, Your Honor, is that, Mr. Hamilton was talking about all the letters that had written, and it's true, they made a claim for indemnification, but Mr. Hamilton had written back and said that he would note under Delaware law it was premature to even consider indemnification at the present time, and he cited cases that stood for the proposition that it is generally premature to consider indemnification prior to the final disposition of the underlying action. And I'm just asking for consistency here in this case. If you have anyone have any other questions?
I don't have any questions. Thank you.
Thank you very much.
This case will be submitted. Now calling item number 13, docket number 378701. This is In re JJ Civiter Minor. We have one party endorsed for oral argument, but I don't see anyone here.
Never show.
Okay, this case will be submitted. Item number 14, docket number 378088, In re Long Minors. Again, we have one party endorsed for oral argument. Okay, seeing no one here, we'll submit that for decision on the briefs. Next is item 15, docket number 373138. This is People of Michigan versus William Gilliam, and I have neither party as endorsed for argument. Okay, would you please approach and state your name on the record?
Yes, sure. Good afternoon. I'm Christopher Sinclair, appearing on appellate.
Not endorsed.
Right.
I'm not. I was asked to be here. I was sent a notice.
Who asked you to be here?
I received notice to the court to be here.
No, we didn't tell you to be here. We just gave you notice of a hearing. If you're not endorsed for oral argument, you don't have a right to speak, period.
Again, I didn't ask to speak. I wouldn't have sat here for 4 hours just to, say that I wasn't endorsed for oral argument. I received the email from the court asking available dates. I provided the available dates. It said be here June 2nd, 11 o'clock. I got here. at 45
The
minutes
court
late.
doesn't summons lawyers.
I hear what you're saying, but I know what.
I know what I'm saying. In the court, I don't want you to misspeak. The court, we don't summons lawyers to appear. We give you a date.
Again, I understand you and I hear you, and I'm just telling you the
I don't think
information I
you do.
received.
If I understand what you're saying you appeared here just out of respect to the notice you got from the court and put your notice on the record, that you appeared on the record.
So that's part of it, Your Honor. And I did receive emails from the court asking for available dates for me to be here. I do know that neither myself nor the people asked for oral argument, and that was indicated in the notices that I received.
Okay.
So, you know, I was given I received the communication that this is where I need to be, so that's why I'm here. And I assumed that the court had questions as it relates to the brief that was filed, and that's why I was here for 3 hours.
I'm going to state for the record, because I think I know where this is going, that nobody from this court asked you to be here, and that if you want to submit for your time to be here, that I would vehemently oppose that, because we did not ask you to be here. You were not endorsed for oral argument.
Submit what for who for time to be here?
We have no questions for you about this case. Since you were not endorsed, we generally allow people to introduce themselves for the record, and then they must be seated.
Okay. So why was I asked for dates when I was available to be here?
Sir, I'm unable to answer those questions about exchanges you may or may not have had with the clerk's office, because I'm not privy to them.
But I don't lie, so we have the exchange, but if there's no questions, thank you so much. Have a good day.
Thank you. Okay, item number 16, docket number 378-655. This is in re JW Minor. No parties are endorsed for argument. No parties are present. So this case will be submitted on the briefing.
Thank you, sir.
That will conclude our case call for today. Thanks very much.